Yes, please. Item number 7. It's a very old matter.
Its expiration, my lord, the family members return the brief to their respective parties. They again approach us last week, my lord.
You wait.
My lord.
Don't make mention of the old matters. Just wait. We will accommodate. But wait.
May I please, your lordship? I beg to mention item number 9 with the consent of the other side. Similar subject matter, another RSA was pending, that is 198 of 16. The both matters may be
That is
listed
not
together.
listed before this.
No, my
today.
lord. Earlier I have also mentioned.
You are
I'm the
appearing in
appellant.
this matter.
I'm the appellant, my lord.
Yes.
I have taken the
Yes,
consent of.
There is a similar matter.
Yes, ma'am.
It's
Yes.
not in the list.
Not.
Your name?
A.K. Hannan, my lord. I am the
Mr.
appellant.
A.K.
Hannan.
Annan. Learned counsel appearing for
Appellants.
appellant as well as Mr.
AHMR Chaudhary.
MS.
AHMR Chaudhary.
So and so Chaudhary. Learned counsel appearing for the respondent jointly submits that the connected regular second appeal being RSA
198 of 16.
198 of 60.
Yes, ma'am.
16.
16.
2016 is not listed along with the instant regular second appeal and seeks listing of the instant second appeal along with the said second appeal together on any other date. Prayer is allowed. List this appeal along with so and so RSA number on when?
17th of June, my lord.
On 17th pare? On such and such date.
Another, my lord, item number 10, our name has not been shown. Today morning, I have noticed that in the cause list, our name.
Item number 10, you say Mr. So and Mr. Your name. Please give your names. Huh?
A.K. Hannan, my lord.
So and so learned counsel for the appellant submits that since their names have not been reflected in the cause list, they could not prepare for the hearing and accordingly seeks a short accommodation. Prayer is allowed with consent.
No, my lord.
You have not taken consent from
No,
the
my
other
lord,
side.
because our name has not been shown.
No, then I am not you. I will give you this order, but you please take consent from the other side first.
Obliged, my lord.
Don't make a mention without consent, please.
Obliged.
Cancel that order now. Yes.
Highly obliged.
Yes, Mr. Bor. Yes.
My lord, may it please, my learned friend is having some difficulty today in item number 12. So he has requested me to accommodate for preparing for some accommodations.
Item number 12.
12, my lordship.
Contractual bill.
Yes, my lord. Lordship.
Yes, what difficulty? This contractual bill matter is pending for hearings. It's a 2022 matter. Mr. Purag, these are admitted dues.
These are all admitted dues, my lord. On the last occasion, your lordship had the occasion to go through the records and order was passed for to be posted on hearing. And they today, some days back, his actually senior told me that he's going somewhere out of station Guwahati, my lord.
All right. Your name?
J. Pegu, lordship.
Mr. J. Pegu, learned counsel appearing for the respondent.
Yes, lordship.
Seeks adjournment of the hearing of the instant writ petition on the ground that his senior, who's leading the brief on behalf of the respondent, is out of station. Mr. H. Buragohai, learned counsel appearing for the petitioner, does not oppose to the said prayer. Prayer is allowed. Relist when?
Any date convenient to my lords?
That date,
The 15th June, lordship.
Item 4, my lord,
Obliged.
filing the additional affidavit. I will be
Obliged,
allowed to
lord.
bring into record, man. Yeah, regarding that, my lord, gazette.
all right. For it.
Obliged.
One second. इसमें पैन कार्ड क्यों देने का?
हाँ.
No, this application.
One second, Mrs. Harwala.
That's not the entry order.
Well, Lordship, Manoj, my
Yes,
second,
Mr.
Mr.
Smith.
Borba is on legs on division bench. He'll be on his resume. Just for time being.
Okay. Yes.
Probably when the record has been received, my lordship, record received, lordship.
Stoppage of 2 increments.
Yes, my lords.
Yes, Mr. Bhattakur.
My primary ground is that the in order, which is reflected from the annexure 1, has not been communicated to me, my lord.
Annexure.
Only from my
This is,
lord.
the punishment is of stoppage of 2 increments.
Yes, my lord.
Yes.
Kindly see page 15, my lord.
Page 15.
Yes, my lord. But this order has been passed by the my lord SP border, where my last posting is there, my lord. Before at the bars of retirement, my lord, this order has been issued regarding my regulation of the increment. So at the
Sorry.
at the bars of the retirement, my lord, I was posted in border branch, my lord. So this order has been passed regarding regulation of the annual increment, my lord. From this order, I could only know that some punishment has been imposed upon me in the year 2000.
Nothing was communicated to you.
No. And affidavit also is silent.
No inquiry.
No,
Inquiry
inquiry was
was
done.
done.
So page 15,
Yes.
clause 2, pay raise from rupees 5080 to rupees 5 so and so with effect from 1/7/2022 instead of rupees 5375 as he was awarded stoppage to annual increment with immediate effect in connection with the department proceeding number 12/1999 by DO number 1725 dated 2/24/5/2000. So
Yes.
after coming to know about this progress, I immediately in annexure 3, page 18, I prefer an appeal.
Annexure 3. Yes.
Yeah, I prepared an appeal as per the
Yes.
Assam Police Penal Part 3 under Rule 66.
Hmm. Yes.
In para 3, I have categorically stated that I have not been communicated the order for his delay has been caused to prepare his appeal also. May I read you?
Yes, please.
Para 3. ma'am.
I'm taking it up for final disposal. So go slow
Oh.
because records are there, isn't it?
Yes.
Yeah, go slow. Yes.
With reference to the subject matter, I have the honor to state that I joined in Assam Police as Science Inspector of Police on 13/6/1987 and thereafter I served my duty in different places with due diligence. Thereafter, in the year 2011, I have been promoted to the post of Inspector of Police and posted at Special Branch, Kailipara. And on 18/8/2018, I have been transferred to the present place of posting, that is Border Branch, Simantapur, and I will go on superannuation on 31/1/2020. It is stated on 31/2020, I received an order regarding regulation of the annual approved service increment, and I was shocked by noticing that by DO number 1725 dated 24/5/2000, I have been awarded a punishment of stoppage of 2 annual increment with cumulative effect in connection with DP number 12/1999, and as a result, it affects my service benefit. I said I could not prefer this appeal within 6 months in view of the proviso of clause 9 of Rule 66 Assam Police Manual Part 3, proviso of clause 9 of Rule 66 Assam Police Manual Part 3 provides that no appeal shall be considered by the appeal authority if it was not preferred within 6 months after the date on which a copy of the order appeal against was communicated to the appellant, and no reasonable cause is shown for the delay. In the present case, I have not been communicated with the impending award of punishment as yet, and for which I could not prefer this appeal on the basis of award of punishment. In fact, preferred this incentive on the basis of the contents of the order dated 31/1/2020, issued by the Superintendent Police Border Assam, which spelled out about the award of punishment. As such, your good sir, would you please to condone a delay in preferring the appeal considering the aforesaid facts and circumstances? Next page. So, but the department proceeding 12/99 is concerned. I said the same was initiated while I was posted during police station as officer in charge. That by letter under memo number so and so dated 27/11/1999 issued by the Superintendent of Police Nagaon. I have been served with the so called notice along with the acceptable allegation and under section 7 of Police Act. Reading with Rule 66 of Assam Police Part 3 and Article 311 of the Constitution of India for not handing over 16 number of case diary to my successor at the time of handing over the charges of during police station. I have been charged with the misconduct and gross negligence of duty. It is pertinent to mention here that along with the so-called notice of the so and so, no list of witness and document had been served to me, though it was reflected in the so-called
So cause notice is dated
is 27/11/1989.
27/11/19.
1999.
9 is missing.
Yes.
Is this show cause notice available?
Yes.
Just give me the page. I'm just noting it. Just the page.
Page 22.
Page 20.
Two.
All right. Yes, please.
It is stated my request to supply the list of document witnesses was denied by the disciplinary authority for the reason best known to them. However, based on the statement of allegation on 10/12/1989, I submitted my written statement before the Superintendent of Police Nagaon, whereby negating the allegation requested to exonerate from the charges. It is that after submission of the written statement, it is not known to me about the fate of the department proceeding. No notice has been issued by disciplinary authority to participate in the department proceeding so as to defend my case. I have been all along deprived of cross-examining the witnesses relied by the disciplinary authority. In as much as no opportunity was given to me to adduce my defense, I say that department proceeding was conducted in a mechanical and cryptic manner, and I have been deprived of my fundamental right as envisaged in Article 311 of the Constitution of India. Read with Rule 66 of Assam Police Manual Part 3. It is pertinent to mention here that under Rule 66 Assam Police Manual Part 3, I am entitled to cross.
No notice also given to you to participate in the department proceeding. Notice of inquiry not given.
No, that is also cryptic. I will show how it was communicated.
Yes, Mr. Goswami.
I am entitled to cross-examine the witness relied by disciplinary authority. However, said mandatory requirement was not followed in the TP number so and so. Moreover, the inquiry report in connection with the TP number 12/1989 has not been served to me as yet. I am not aware of the finding of the inquiry officer. I have been deprived of submitting the representation against the finding of the inquiry report. It is said that if I would have been served with the inquiry report, I would be able to give my reply to the finding of the inquiry. As such, I say that department proceeding was conducted by violating the mandatory rules and depriving my right as enunciated in Article 3 and 11 of the Constitution of India, as well as violating the natural justice in every step. Then next para. Further, imposition of punishment of awarding stoppage to annual increment with cumulative effect is not sustainable. It is stated clause 2 of Rule 66 Assam Police Manual Part 3 does not prescribe the major penalty of punishment of awarding stoppage of 2 annual increment with cumulative effect. Rather, it speaks about the withholding of increment. However, due to aforesaid impugns of punishment, it affects into my entire service increment, and it has come all the time, and it may affect my pension and retirement benefit also. I say that in the absence of specific prescription in the rules, a particular penalty cannot be imposed, and on that count alone, the impugned penalty of stoppage 2 increment with cumulative effect is not sustainable. Then next para, I said I have not been communicated with the order imposing punishment of stoppage of 2 increment with cumulative effect. I have come across the said information about the imposition of punishment only on 3/1/2022. I said that mere passing of an order imposing of punishment and cap with itself cannot be a given effect unless it is published and communicated to me. Then
Just taking a pause here, Mr. Goswami, is this position correct? Has this order been communicated or not? Was he given a notice before imposing the penalty?
Lordship, my record reveals that there is no such type of my record is not evident that the inquiry report was furnished to the petitioner.
Then that is then there is he has made out a case.
Lordship.
On that ground alone, it is not perhaps necessary for this court to go into so much details if that is so, isn't it?
Lordship, my My submission is that, Lordship, from that stage, Lordship, may I allowed to proceed from that state after issuing the proper inquiry report to the petitioner and
But
get-
what about list of witnesses and all?
already he participated in the
No, but
inquiry.
whether the list of witnesses was
Yes,
given
yes,
to him,
yes,
because
Lordship,
there is
that
in
was
his
furnished.
representation, he
Yes.
said that it was denied.
No, that was furnished. Lordship.
Which document you
Yes,
have to
Lordship,
show
yes,
that
Lordship.
list
Yes,
of
Lordship.
documents and witnesses have been
Yes,
given to
Lordship.
him?
Yes, Lordship.
Because he is
Lordship, we have the,
Mr. Bhattakar, I'll come back to
Yeah.
you.
the in the first so cause notice, Lordship, it is on 27/11/1999,
Page
Lordship.
22.
Lordship, it is in my, I am on record, Lordship. It
Hmm.
appears that the statement of allegations as well as the copy of the report submitted by the report submit, list of the documents is there and list of the witnesses are there, Lordship.
No, in the body of the show cause noted is there, page 22. Page
And Lordship,
22, this your reading is from the notice dated 27/11/1999.
yes, 27/11/1999,
Hmm.
a so cause notice was issued, Lordship.
Yes, in
Yes,
this, the
in that-
list of document, copy of report submitted by so and so.
Yes, Lordship.
And name of witnesses.
The name
four
of the witnesses, Lordship.
Now,
Yes,
and then statement of allegation is there.
yes, a statement of allegation is there, Lordship.
This is the first show cause notice.
Yes, Lordship.
Now,
And he replied,
where is his reply?
yes, he replied, Lordship, it is on 10/12/1999.
Yes. Page 28.
Page 28.
Yes.
And
And that's a department information. That's out of 16 cases, so and disposed, diaries, and has not been handed. And that's could not be furnished, as the medical report could not be procured. He has given some explanations.
yes, Lordship.
Hmm. So he have not taken a stand here that these things were not given to him,
Yes,
right?
yes,
Right, Mr. Bhattakar?
Yes, in a represented.
So then, if you are agreeable, I can send it back to that stage.
After
Yes.
so many years, after retirement, and how it is to be conducted.
No,
to
but
see,
your
please.
reply, you see, Mr. Bhattakar, the reply, after going through the reply, it appears that there could be something. Now here, it is not a case of that there is a no case made out.
Yes,
It appears procedural violation as
Yes.
regards not giving you an opportunity.
now how the proceeding has been conducted.
Are you carrying that authority?
Lordship.
Are you carrying the authority that on natural justice
Yes,
before imposing the
before
penalty?
when we received the Assam Police Manual, is Rule 66.
Give me the Rule 66.
Yes. In my book, the Rule 66 is at page 268.
Yes.
Now, Rule 66 clause 12. Clause 12, subclause E,
Clause 12.
subclause E.
Yes.
A copy of the full order shall be entered in the district order book that they have mentioned the DO order, and copy of the thereof furnished to the delinquent. His dated receipt being taken for it and attached to the proceeding.
Now this is about which book? Nothing.
Rule 66.
No, but copy of the full order means what full order?
This is the impugn order. It is the.
The full order means what? The inquiry order?
No, the impugn order.
The
The punishment.
imposition. But
Yes.
before imposing the punishment, are you not required to be heard?
Yes, obviously.
Where is that requirement?
Rule 66, clause 3.
Because that also is not complied, right?
Yes.
Yes.
No order of major punishment shall be passed on a member of the service unless he has been informed in writing of the ground on which it is proposed to be taken action and has been afforded an adequate opportunity of defending himself. The ground on which it is proposed to take action shall be reduced to the form of definite charge or charges, which shall be communicated to the person charged together with a statement of the allegation on which each of the charges is based, and of any other circumstances which is proposed to be taken into consideration in passing the order on the case. He shall be required within a reasonable time to put in a written statement of his defense to state whether he desire to be heard in person, if he so desire, or if the authority concerned so directs an
The
order.
rest of the things are done.
Yes, then my next para. At the inquiry, oral evidence shall be heard as to such of the allegation are not admitted, and the person charged shall be entitled to cross-examine the witnesses to give evidence in person and to have
So that you participated in the inquiry.
how it is participate also.
No, you have any grievance in the inquiry proceeding also.
Yes,
Before the inquiry officer, you were not allowed to cross-examine.
yes.
No,
In
no.
para 8, I
Huh?
have stated how the inquiry officer
No,
conducted the proceeding. Because the notice, his
Hmm.
first notice, it shows the notice has been issued to all the witnesses. And thereafter, what prompted them to again issue notice to the witnesses?
No, that is all right. Have you got a chance to cross-examine or not?
So as per the record, I have not been given.
You have been
Yes.
given.
I have not been
The-
given.
No,
But
no,
it
as per
says-
the record, he has been given.
He has been
Yes,
given.
he
As
got
per
the
I have
opportunity.
stated that
Then,
the inquiry officer has gone to my office.
No,
to-
Hmm.
not like.
The inquiry officer has gone to my office to get my signature in a papers.
No, not like that. That was not raised.
I have raised.
Where?
So,
The
at the
record-
time inquiry, oral evidence shall be heard so as to the allegation as are not admitted. The person charged shall be entitled to cross-examine the witness to give evidence in person to have such witnesses called as he may wish, provided that the officer conducting the inquiry may for the.
you have the record?
Yes, Lord.
Show the inquiry proceeding.
Yes. I flagged it, whether he got the opportunity for cross-examination, Lordship. When the inquiry officer asks him that to whether you are you are ready to cross-examine it, that he denied, Lordship. That is in I marked it in the flag marshal, the page of the flag marshal. Flagged.
These flags.
Yes. These are the witnesses, Lordship. In the last page, in the
Statement. These are the statements.
yes statement, Lordship, in in this statement, Lordship, recorded to the witnesses, Lordship. In the last in the
It's in
last portion
Assamese.
of that page, yes. Last
Everything is
portion,
in Assamese.
yes. Last portion in the page, Lordship. His signature is also there, and specifically asked by the inquiry officer whether you would like to cross-examine, that he stated no.
Prashna, this one.
Yes,
I will see
Lordship.
on which that made the statement of the recorded.
27. This is there. 27/3/2001, right?
Lord.
This is 2000, sorry. Yes, you were there.
No, my lord.
The
My
record shows.
But then my lord, see page 52 of the affidavit, my lord.
See, Mr. Bhattakur, you
No, but
have
we
to
did
appreciate
notice-
that you are
we did
before a
notice-
very limited jurisdiction.
Yes, I know. But-
Yes, because this court cannot now sit and appeal against the
Yes.
decision. This court will have to see if there is any procedural irregularity or if there is an error apparent on the face of the record or in the
But
decision-making
I have
process.
got a judgment which says that the infirmity is so high that court can go into the.
So that
case aspect.
infirmity has to be shown because you
Page
see,
52 kindly see, my lord.
with one of your point, this court is
Yes.
with you that it appears that they have not given you a notice before imposing the major penalty. Because here admittedly, the penalty imposes a major penalty,
Yes,
correct?
obviously.
Mr. Goswami?
Lordship.
So that is one violation.
That's why.
The
Second-
inquiry report must be furnished to the petitioner. It is our law also.
So that is also not done.
No.
So on those grounds, yes, you have a case.
Now, madam, for
But-
a moment, madam, kindly see page 50.
Prior to that, as regards the quashing of the inquiry,
Yes. Now, madam, say for a moment, page 52. Whether
Page-
appears-
and
page
even
50
if this court will set aside the inquiry, this court will always give the liberty
Yes.
for them to
Yes.
start a fresh inquiry.
For my satisfaction, my lord, kindly see
Page,
page 52. Of the affidavit.
Page 52.
Yes. I'll be respond number 6, my lord. The SP know.
Yes.
This is a WT message sent to the
52
witnesses
is
number.
an inquiry report.
Now, page 52 of their affidavit. madam. Of the affidavit. 52, hai na?
Yes.
There's no
Yes, it is
50
24.
Huh?
That record was
Yes.
Sorry,
27 is the record.
Page, my lord, get it, my lord? Page 52 of their affidavit.
52 is something else.
Is a WT message.
57, I think.
Yes.
Yes, appear before.
Yes, so and so to SI Jadab Boyso, Lambding PS, CI, this is PW1. Then SI open of the petitioner, police reserve so and so, info OC Lambding so and so, CL number so and so SC 243034 dated 24/3/2000. Appear before in so and so 27/3/2000. My
Yes.
lord get it in the record also. But my lord get the receipt
No,
signature
appear is when?
27/3/2000.
Appear before me on 4/3, it says.
Yes.
You are at page 57, right?
No, 54.
Jadav Chandra Basha.
Yes.
No, then appear before me on 4/3/2000 at 10 hours. In my
But
office
they have
chamber.
next three WT messages. One is of 3/3/2000 to appear before the inquiry is on 4/3/2000.
Yes,
That seems to be received by the petitioner.
yes,
Then second one is 6/3/2000. Asked
yes.
me to appear before the inquiry
On
on 7/3.
7/3/2000.
That no receipt signature of the petitioner.
Then
On 6/3/2000, there is no signature of the petitioner. Which shows
this is
that-
for appearance of whom? One of the witness,
yes.
which is what is the name? To OC.
6/3 is of my lord is issued to OC Dhing, that is PW3.
PW3.
3.
Now,
Yes.
when did PW3 appear?
Yes. Well,
Let's check
Lord.
the dates. When did
Sir,
PW3
well, see,
appear?
but my Islamabad seems to be recorded on 27, but it was not received by me. Did not miss.
Wait করো। Wait করো, দেখে দিই। Lordship, witness Kamaleshwar
OC Dihing.
Talukdar, Lordship.
Hmm.
The statement was recorded, Lordship. It is on 4/3/2000, Lordship.
On
Kamaleshwar
4/3/2000.
Talukdar.
4/3/2000.
4/3/2000. And another, Lordship,
Was-
Chandrakanta Borua. Witness,
What about Jadav Chandra
yes,
Borua?
Jadav Chandra, Lordship. Yes, Jadav Chandra Boyso, he
Ah.
was examined on 27/3/2000. Lordship.
No, but his notice said it says 4/3/2000. So this is not clear a little bit.
Yes, Lordship. I think,
24, I have not
Obviously,
received.
Mr. Goswami, you understand what Mr. Borthakur is trying
yeah,
to
yes,
do.
Lordship,
Hmm.
Lordship in
But because in this notice, he has given his signature.
Lordship, Lordship, in page 25 of my record, it appears that he was directed, Mr. Jesse Jadav Chandra Boyso was directed to appear before the EO on 27/3/2000, Lordship, at
He is not
10:30.
understood.
But here it says 4/3/2000 in your affidavit.
No, it is in record, Lordship.
No, but this is your document.
Yes, Lordship, let's see, let's
Come
see.
to, come to
let's
page
see the-
57.
No, I have, in my affidavit, Lordship, I have not seen the page 57, Lordship.
No, you see, it is there here in the court's copy, 54.
54, yes, 54 is there, Lordship.
On
54,
top-
Lordship,
You see OC Dhing,
yes,
then down you see Jadav Chandra Boitsa.
yes. Just a minute.
Can you see his name?
Yes, I got it, Lordship, I got it.
And now you see appear before me on 4/3/2000.
Yes, Lordship, that
And
is.
this is signed by UN Sharma.
Even so, now, Lordship, this from my record, it reveals that Jadav Chandra Boiso, yes, Jadav Chandra Boiso, SI Jadav Chandra Boiso, Lomding, was directed to appear before the EO on 27/3/2000.
Yes.
It is in record, Lordship. Again, Lordship, it is stated.
See, Mr. Goswami, what you
Yes.
have to demonstrate before this court is to show that whenever these dates have been changed or fixed,
Lordship,
whether he has been also put in a notice. Suppose he's present,
Lordship,
then it is all right.
right,
But if he is not present,
Lordship.
how have you told? Because he
Look,
has to
no.
know. Because he's trying to say that he was not there. Is that position
No, but
correct
the-
or
but
not
the-
correct?
But
You
the,
have to ascertain it from the record
yes,
carefully.
I got two notices, Lordship.
Hmm.
Here, one, it is directed to appear on 27/3, and another, Lordship, it was on 4/3. And record reveals that Jadav Chandra Boiso was, the statement of Jadav Chandra Boiso was recorded
On
on
27.
27/3,
That I
and that
saw.
was acknowledged by the petitioner.
But how did the petitioner, because now he's saying his signature is also taken forcefully.
When
or
I
something.
pleaded.
Just a minute. Lordship, on that count, I would like to say.
Now,
Yes,
you must
yes,
show
Lord.
me the notice by
Yes,
which he was
Lordship,
informed.
Lordship, on that day, another witness was examined. He is Chandrakanta Borua. That was not disputed by him.
That
On
notice he has
27,
received.
yes, 27.
That
It
notice.
means 27, the petitioner was present before the inquiry officer. Because two witnesses were examined. One Jadav Chandra Boiso, another Chandrakanta Borua. Regarding Chandrakanta
All right,
Borua,
counsels, I think I will need to have the dates. I
Lordship.
wanted to dispose it right now, but it appears the dates are
Lordship.
getting complicated.
Lords.
So, Mr. Borthakur, you give me a gist of your allegations.
Yes.
Share it with Mr. Goswami. Mr.
I will
Goswami,
counter it.
you
Please,
counter
yes,
it
yes.
with the page numbers.
Yes,
We'll
Lordship.
have it on Thursday.
Lords.
This Thursday,
Lords.
day after. Day after, because I'll forget. You just have to do a little homework.
Lordship, no issue.
You do it, Mr. Borthakur, today, give it to him tomorrow
Yes,
morning.
yes,
Tomorrow,
then-
give
then-
him,
Yes, Lordship. I
burn the
will draft.
midnight oil.
I will draft. Lords.
All right. In part, refix on Thursday.
Lord.
Give me you properly prepare the list, the gist of your allegations, whatever your allegations are that you have not got. And Mr. Goswami will counter it by correspondence pages,
Yes, from the records, Lordship.
because that is the only thing I can
Yes,
see.
yes,
I
yes.
cannot go beyond that.
Yes.
And
Must-
also
must-
to refer to the relevant,
Can it be on next Tuesday, man?
all right, Tuesday.
Next Tuesday, Lords.
I'll get the Sunday also.
That was item 1.
May I please your lordship?
Yes.
We are agreed by the impugn letter at page 53, letter dated 29.
Affidavits have been all filed.
Yes, lordship,
Allotment of land.
allotment of land, DGR land, lordship. Before I come to the impugn letter, lordship, I beg to draw your lordship kind attention to the facts of the case, lordship. Lordship will find where annexure 1, page 27.
What is the challenge?
Lordship,
Challenge is
challenge is regarding
setting
against
aside
the
quashing the
impugn letter
letter.
dated 29/9/22, by which
Where is this impugn letter? Page?
page 53, lordship.
Page
53, 53,
53.
by which the respondent number 9 was allotted the land which we are in occupation laws. May I read, Lordship? With reference to the subject stated above, I am directed that the Borderland Territorial Council Procedural is pleased to order for allotment of land measuring 1 figure 3 quarter 10 lesser covered by VGL Dag number 1039 of Business Town under Business Border of Business Regulations District Shirang to Bhato Ashram Community Hainanagar Business District Shirang subject to utilization of the land for specific purpose. The land so allotted will automatically stand cancelled and reverted to BTC in Revenue Department if not used for the purpose within 3 years for which it is allotted. The proposal was approved by the LSC business meeting held on 15/5/1997, number 20, that resolution in favor of Business Town Saurang ME School. However, the land is proposed to be allotted in the name of Bhato Ashram and Community Hainanagar Business PS Business District Shirang instead of Business Town Saurang ME School Business after renaming the institution as per Circle Officer's report. The land record may be corrected accordingly after handing over the possession of the land to the allotee committee. All relevant documents received in your proposal under reference returned herewith for necessary action. We are aggrieved by this law. And we are in occupation since.
No, and I'll fix it, I'll admit it and post it for hearing. And
Now,
I am appearing for respond number 9. There is a ashram also. We offer the
let
land
me
for
finish, Lord.
easy
I'm
payment.
posting it for hearing.
You lost a short date maybe.
Yes,
He-
yes, I'll
he's
give a
taking
short date.
the-
Lordship, now the Honorable Supreme Court has already laid down the law.
So I'm posting a matter for hearing. You
No.
have any problem?
Lordship,
Admit the matter, the matter requires a full-fledged hearing. Admit no formal notice as parties are represented by their respondents are represented by the respective councils. On top also you say pleadings are completed, huh? Post for hearing. When do you want? In the month of July?
summer vacation.
In the month of July 2025 on a date to be fixed by the registrar.
Date maybe.
Yes, next.
Because it's getting,
Interim order may
The
continue.
interim-
Lordship.
Interim on, if any, shall continue
may
to
be.
the next date of.
Oblige, Lordship.
Yes.
oblige.
May I please, Your Lordship? My lord, matter pertains to non-issuance of PRC, my lord. My
Hmm?
lord, by order dated.
Issuance of PRC,
PRC.
permanent residence certificate.
Yes, my lord.
Why you are not getting it? Yes.
It is
Mr. Roy?
rejected, Lordship.
Rejected.
Rejected.
You have the order.
Yes. My lord, by order dated 19th.
Have you filed it or not? Affidavit?
Not filed, but on the last occasion, Honorable Court has asked to provide him the copy. Yes.
Sure. In this, the prayer is for issuance.
Yes, my lord. This is the online. With my vision.
Then perhaps your writ has become infectious.
Infectious, Lord.
No, my lord, I have.
It's rejected.
No, my lord, I have challenged this, my lord, this order, though this order was issued subsequently, my lord. But petitioner was informed, my lord. I have challenged that information letter, my lord.
You have challenged calling upon the so-called as to why a writ in the name of mandamus or any other appropriate writ order or direction shall not be issued directing the responsible authorities to issue PRC in favor of the petitioner at the earliest. You are saying issue PRC when
It
the
was
authorities have dismissed,
rejected.
rejected. This order of rejection is not put to challenge. How will you get this relief if you don't challenge this? Mr. Counsel, please enlighten the court. How will this court grant you a mandamus if you are not seeking a challenge to the rejection? Please enlighten.
Yes, my lord.
Please enlighten the court. You are saying issue me PRC. Then you say you already knew about the existence of this order, but you don't put this order under challenge.
By way of communication, my lord, they have informed me, my lord.
But you don't put it under challenge. You are not challenging it. Where in the prayer you have said set aside this order? Where have you said? Are you withdrawing it or with liberty or I'm going to dismiss it?
With liberty, my lord.
Heard Mr.
AHMR Chaudhary.
So, Pala Namtu, to and so learned counsel for the petitioner, also heard Mr.
Yes,
SS Roy,
Lordship.
learned
Government.
government counsel for the state respondent. The issue involved in this writ petition, no, the prayer made in this writ petition under Article 226 of the Constitution of India is for issuance of a mandamus by way of a direction to the respondent authorities to issue permanent residence certificate in favor of the petitioner. Today, when the matter was called, Mr. So-and-so Roy, learned so-and-so, furnishes a copy of the order dated 1/5/2025, by which the application of the petitioner for issuance of PRC was rejected. A copy of the so-and-so is kept on record and marked as X. Mr. So-and-so seeks withdrawal of the writ petition. At this stage, Mr. So-and-so seeks withdrawal of the writ petition with liberty to file afresh. Prayer is allowed. Writ petition stands liberty. Stands dismissed on being withdrawn with liberty to file afresh.
Obliged.
Disposed of. Yes, what is this?
Lordship, perhaps I have not received any further instruction.
You have not?
Not received any further instruction. However, Lordship, due to health issue, I am not totally prepared.
Sorry?
Due to my health issue, I am not prepared on today.
You want another date?
Only short date.
Heard Mr. B. Fukan, learned counsel, B. Fukan,
Before.
learned counsel for appearing for the petitioner. Also heard MS MD, learned counsel appearing for the respondent bank. Mr. B. Fukan, learned counsel, submits that he is not feeling well and accordingly seeks an accommodation, short accommodation. Prayer is allowed. Relist when?
Friday.
Next week, Lordship.
Relist next week on a date to be fixed by the registrar.
Yes, Monday,
Yes, next.
next month.
Matter had come on the
Yes.
last day.
Yes, last day, my lord, yesterday, my lord, you also heard it. Well, here what happened, my lord, the so-called notice was issued by manual
That
thing.
blacklisting,
My lord,
blacklisting matter.
yes.
So I
So-called
think
notice was issued by the managing director. And impugn order has been passed by the general manager,
show cause by
managing director,
MD
MD.
and
Impugn order is by general manager.
GM.
Yeah.
Where is Mr. Gogoi?
Lordship, I'm extremely sorry. We are running around in between courts.
Huh?
We are running between courts.
All
I'm
right, no
extremely
worries.
sorry, Lordship. Lordship, regarding this case, we have received the records as well. And I'm apologetic to your Lordship as well as the senior counsel. Lordship, can this matter be taken after some time? Let it be placed by him. We have received the records and everything.
I think there's another matter of yours.
Yes, my
Hmm.
lord. That is also, my lord, Mr. Barbara was there. He took time, I think.
Is he there, Mr. Barbara?
No.
Hmm. Chalo, Mr. Pran. You let us know.
I'll
You please inform Mr.
Lord-
Sahewala when Mr. Gogoi is here.
Lordship.
Otherwise, he's been sitting here for a long time.
Lordship.
I think 4 also we will need Mr. Gogoi.
Lordship, we will need. We have served the affidavit and.
Yes, what
additional
is official gadget, Mr. Sharma? Have they?
No,
Huh?
it was not gazetted.
Oh, it was not gazetted. Then I think
Lordship, we.
And now,
yes, any further arguments to be done by Mr. Gogoi? Otherwise, I will hear
I
Mr.
think the-
Sharma. Huh?
Regarding the gazette notification, Lordship, it was notified on 28/1/2022.
no, that is an earlier, this.
One second.
Annexure C, Lordship.
Where is the affidavit? Khan put us?
I believe it's,
আজি
Lordship, we have an extra copy.
ইয়াত অহা নাই নেকি আহি পোৱা নাই
I have.
কল কৰিছা yes where
Annexure C, Lordship. That would be page number 189.
yeah this is 28 January 2022
Lordship.
Lordship, may please come to the
But,
affidavit that page 180.
1 second but you see your first tender was 3/10/23
Lordship.
you did not insist on government gem
Yes.
then your second tender was 16/11/2023 then also you never insisted on this third is 9/1/2024 now you open the financial bid not on this ground and then sorry the technical bid
But on the financial.
and then you decided no we will open the financial bid after opening the financial bid suddenly you are now insisting on GEM and this appears to be a notification which has been published way back in 28 January 2022
Yes, we have inquired, my lord, finally we have
Mr.
found that.
Gogoi, the court's query is if this notification was mandatory and it which you are now trying to project and if this notification was gazetted way back on
Yes,
28th of January 2022
Lordship.
why your first tender on 3 October
Then
2023 was
necessarily
not
that
under
question will
GEM?
come, my lord.
Why your second tender was not under GEM?
I understand, my lord.
Retender, you see second retender and third retender again on not under GEM. Despite that, you open the technical bids. After opening the technical
There's
bids,
a
you
fact.
decide to open the financial bids. And after opening the financial bids, after you know the rates of the parties, then you decided to no,
Yes.
now we would follow GEM because GEM is mandatory.
This is a fact, my lord. This is a fact, I can deny.
And that GEM thing which came on 8, what was that? That one
That
OM,
is the office memorandum,
which is that?
That
office
is 8
memorandum?
January
my lord, that is a part of our.
2024, page 105.
Page 105. Now, you see that now, and the question that was put to you by this court was in relation to that OM, because what Mr. Sharma has contended before this court is that any notification that you bring has
Yes,
to
that
be
we have
gazetted.
replied, my lord. Lordship, may kindly see page
1 second,
182.
1 second. Page,
Page
Mr.
180.
Sharma, page
Page 105.
105. 105. Now, this is
Now, Lordship, the
These
in the
are the-
first line, Lordship will read in superstition. Lordship, get
of
it?
all previous
In
notifications.
superstition,
Of all
then
previous notification related to to e-procurement dated so and so,
Including.
and 28th January 2020.
that is also there.
Yes, yes.
Where?
At the fifth line, Lordship. Jam notification number so and so.
Ah, I got it. GEM notification. So this has been superseded on 8/9.
This is a fact, my lord, we cannot change it.
See, Mr. Gogoi,
Whatever
you see,
was
Mr.
there.
Gogoi, I am not on you.
Yes.
You neither
Because we
can
cannot
you
hi-
go against your facts, nor this court can.
Yes.
What is there is there. Now, when I am saying, I meant the official records. I
No,
don't
my
mean
lord,
anything to
Yes,
you,
on
Mr.
the day when the
Gogoi.
decision was taken, my lord, the 8/1/2024 was
But
the notification
the
available.
fact of the matter remains is that this
It will have to be
notification,
gazetted notified.
8 January, is not, admittedly not gazetted. That is the
my lord,
bottom
what
line.
the authority has said is, my lord, this is the office memorandum. It has been issued as an administrative order. That is what they take control.
That this court will note it.
Yes, yes.
But this court is not going to accept that
Yes.
condition.
I leave it to your lordship on that point. But this is a fact. my lord.
Leave it to me. That is the fact, Mr. Gogoi. That is the fact.
Lordship.
Sometimes you have to own these facts.
So that's why we have put it.
You
back
have
in the
to
affidavit.
sensitize your
No,
department.
in fact, we have
because,
already,
you see,
yesterday, my lord,
these procurement are important.
lordship.
And so it is more important that there has to be transparency, fairness, right? But they cannot just
It
do
will
what
now
they
be
want to
notified,
do.
my lord. It has been brought to the knowledge of the finance department. Definitely
Yes.
will be notified. Otherwise, my lord, it will have no force, my lord.
Anything more?
Otherwise, my lord,
Affidavit খন ক'ত আছে? Anything more from you want to show from this additional affidavit?
no, my lord, these are the facts, my lord, otherwise. On
Have
inquiry,
you
yes,
enclosed those two documents which
Yes,
last
yes,
time you
yes.
had shown me?
yes, my lord. Lordship will find it at page, my lord, 184. This is the letter of the General Manager, Procurement, Assam Medical Service Corporation Limited. And next is, my lord, from the principal, AMCS, along with the enclosures.
And the second one was?
At page, my lord, 185. I have annexed the, my lord, communication which has been issued to me because, my lord, this was not communicated to the DME. So it
I
is
just have
finally-
forgotten. What was the second one?
Second was, one was regarding that, my lord, opening of the financial bill.
Oh,
That underlying point, they have admitted that it was open, but it was
according
not
to the
up.
minutes.
Yes, ma'am.
Were open through online mode, not signed and endorsed.
And in fact, my lord, whatever is the rate of the petitioner, that is also there, my lord, at page 187.
180?
7. 188, my lord, yes. 188 is the petitioner. His rate, my lord, at the, my lord, right hand side, my lord, corner.
Yes.
Among the two, my lord, technically qualified bidder, he appears to be at that point of time to be the one, L1, otherwise. So
Anything else?
I cannot improve my case, my lord. I don't think-
Yes, Mr. Sharma, your closing statement?
Yes. Judgments, my lord, are there, my lord, but on general principle. I will just give the citation and the para. Lordship may
Don't
refer
burden
it
this
up.
court unnecessarily, Mr. Gogoi. Give me one if you want.
Yes.
Otherwise, the principles are all well settled as far as
No.
contractual matters are
No, my lord,
concerned.
regarding that, my lord, being a L1 or L2 doesn't
I am
confer
not
any
on all
rights.
this. I am not on all this.
That's it. Yes, my lord, on the first.
We are not on all that. Whether you definitely have your rights,
That's it,
but the question is how you have taken the decision, the manner.
my lord.
There are so many procedural violations. You are insisting on a GEM mandatory where you don't even official gadget. Now you pull out in your affidavit, you pull out some old
No,
gadget.
we are not saying
No,
just
I am
on
just saying,
inquiry.
you
That's why
see-
word is on inquiry. Now they have
You
informed
see,
the finances that this is the.
And
as a
that
certificate.
the OM says
It's
supersession.
supersede, but it has not been notified. So as on date 22 remains otherwise because subsequent 8-1 has not been
Your
notified.
But you are saying OM.
We go by the argument of the
Then
petitioner.
you see, Mr. Gogoi, then you should have said as per the gazetted notification.
No, we cannot say minute says my lord 8-1, affidavit says 8-1.
That's right.
Yes.
That is where the difficulty
Because
is.
my lord 8-1.
The application of mind.
Lot. Subsequently, this has come to our knowledge.
Anyway,
Anyway,
all right. Yes, Mr. Sharma.
yes. Be sure. Records, my lord, whether lordship will again.
I am going to dictate it right now.
Lordship.
So just
Lordship.
be patient. When I need the records, you'll have to give it to me.
Lordship.
Yes.
Given a small write-up, Lordship, please. I'll give a copy to my learned.
Yes,
friend.
please. Kuntu, you said this is small.
No, these are the judgment, Lordship, I have already placed, Lordship. I have
Yes.
already placed, Lordship. Judgments already, I have read that day, Lordship. I have given the copy to you, Lordship. Lordship, here, Lordship, may please come to page 3. First come first, Lordship.
One sec. Yes, page 3.
Page 3. 1.2.
Yes.
Along with this, Lordship may please take up this page 185 of the today's additional affidavit, Lordship. I know my learned additional advocate and he is very fair in the court and he has shown everything. Your Lordship being a responsible officer, Lordship, and
Yes.
he had to do that. Now here in this document, Lordship, page 185. Lordship, in between, they have lined it according to the minutes of the tender financial bid so and so. Lordship has seen that.
Yes.
Then may I read slowly, Lord.
Yes, please.
But in view of the aforesaid government notification, the committee member recommended the principal cum chief superintendent and superintendent Assam Medical College Hospital, Dibrugarh, not to floor a fresh tender through GEM portal. Now, pausing for a moment. Here, that day Lordship has shown me from the record that the principal has written something on the top. And then there is some correction of date and all that. This part is missing in this letter. Even in the instruction to the, this is a letter dated 25/4/25. When the argument going on, first affidavit, it is silent. When the first affidavit filed, first affidavit in opposition, there they have silent that the principal cum the superintendent has given any reason, or even Lordship has said the postmaster, he has, that is also missing in the affidavit, in the first affidavit. This is the second affidavit. In the second affidavit, and one document they have annexed, that is 25/4/2025. There also they have not written that after the committee has recommended, he has put his mind and written something on a particular date. That is also missing in this letter also, and this affidavit.
What does this letter say?
In the minutes, this is not there.
Now, this letter is otherwise from is issued by whom? The
It
superintendent?
is by the superintendent.
Huh?
Yes, superintendent.
Superintendent.
Both of them have signed.
Both of
sides.
them have signed.
Respondent 4, who has filed the first affidavit.
The R4 is the principal cum chief
Yes,
superintendent, right?
yes, Lordship.
He is the competent
Yes,
authority.
yes. Is the
Huh?
tendering authority.
Procuring authority.
He is silent, Lordship. That after this recommendation, he looked into the matter and he said, let us go for a gem. That is missing. First affidavit, there is not a single whisper regarding that. That after the committee recommended, there is a full stop, Lordship. The committee recommended accordingly gem. That is the first affidavit. And the document is annexed, wherein they said this is the office memorandum, and this office memorandum, we have taken the decision. Now, Lordship may come to page 3 of my written argument. 1.2. Their non-communication
One
of
second.
reason coupled with the response number 4's contradictory stand in the
Where are
affidavit.
you reading?
Lordship at page
1.2.
3.
1.2.
Yes, 1.2. Non-communication of reason coupled with the response number 4, contradictory stand in his affidavit and instruction smacks malafide. The aforementioned non-communication is submitted to have been less the malafide motive, since the tender was cancelled after the petitioner was found to be the lowest bidder in the tender process, whereby his quoted trade was so-and-so as against the respondent number at so-and-so. The malafide of the respondent number 4 is further writ large on the record of the instant case as admins from the following. A bare consideration of paragraph 10 of the respondent number 4's affidavit in opposition, read with paragraph 15 of the instant writ petition. In the latter, the petitioner specifically pleaded that the third tender process was arbitrarily cancelled pursuant to his bid having been found to be the lowest one. However, the former paragraph of the affidavit in opposition, respondent number 4, unequivocally denied the contents of paragraph number 4 of the writ petition. In the writ petition in paragraph 15, I specifically mentioned, Lordship, that I have been informed that my tender, the financial bid was open and I am the lowest bidder. I have been informed. Made, they denied. in their affidavit. A specific denial, Lordship. Unequal denied the contents of paragraph. Yet, as the case stands presently, the respondent number 4 has himself, by means of a written instruction, contradicted the contention of the affidavit in opposition. Now, this letter, Lordship, there's nothing. Pursuant to his Honorable Court's order dated 9/4/2025, the aforementioned minus dated 20/2/2024 came to be placed before the Honorable Court. It is worth mentioning that the same was never pleaded about the respondent number 4 yet. That copy was given to me. He was very open. He has given that these are the document, you take this, and he has given the copy to the court also on that day. On that day, that document was not before the court. Court has specifically said that they bring the record and place it before me. There is a specific order from this court. 9/4, Lordship, you can see. Because in a order passed by the court,
9/4?
9/4/25. 9/4/25.
Yes.
Last paragraph, Lordship. Accordingly, this court permit the respondent counsel to produce the relevant record before the court on the next date fixed to show as to whether the financial bid. Lordship, it is very specific. It is very specific, Lordship. Accordingly, this court permit the respondent counsel to produce the relevant record before the court on the next date fixed to show as to whether the financial bid were opened or seen by the respondent authority or seen by the respondent authority in the process of the third tender before calling for the fourth tender. Now, on that day, I have shown the paragraph 15 to court. On being satisfied, court said that this is an allegation and you have denied, then you produce the record. And
Now they have shown and they have admitted.
not
yes,
now,
they
no,
have seen,
no,
but
no,
not
not that
communicated.
day, not that day, Lordship.
But later they have.
Then Lordship, no, Lordship is not. It is not. On that day, these are the documents they have placed before the court.
On that day it was not. But Mr. Gogoi, I remember he did mention that.
Yes,
this-
is
in
now-
fact, my lord, it
now.
is recorded in the court's order that I have furnished, my lord. No, this is what sort of.
All right, all right.
I placed it is, I am holding this one.
On that day, it was not there. He has not shown that document. It was
See,
not
but
there.
end of the matter is that they have opened it.
Yes.
And
Yes.
now
Now-
in that affidavit,
So-
they have given your rates also. In this affidavit.
Yes, yes,
And they admit that you are L1.
yes. Now they have come, Lordship. So all these, Lordship, these things are there. So I have given a small note, Lordship will look into it. And Lordship, I leave it to your Lordship because it is a third tender, Lordship. And every year, Lordship, in the second tender also, it is after this started, they have changed the rules, so all the tender was cancelled. It is not that when one document is not given by all the parties, so the technical bid of all the bidders was cancelled.
Sorry, I didn't
In
get
the
you.
second tender, they have changed the rule.
But that you have not challenged.
So no, that is why, and I'm not on that.
So that chapter is
So
over.
only my year is the Lordship at page 22 of my writ petition, prior to B, Lordship.
Page
Lordship,
22.
Page 22.
Yes.
This is the B, Lordship, prayer B. Mandamus should not be issued directing the respondent, more particularly the respondent number 2, 3, 4, and 5, award the contract of the advisory service Dubuga pursuant to e-tender the constituency after evaluating the financial bid of the petitioner and performance. That was my year, Lordship. Now it has come that they have already opened and they have evaluated. So, this is my humble submission before Lordship. Lordship will decide. It is the decision-making process, Lordship. I am before the court. I am grateful, Lordship. The judgment I have already read, Lordship, on that day, so I will not.
Just citation and.
Only-
Lordship will just mention
One
it.
sec, I'll come to you.
Only one thing, Lordship, in the book, Lordship, page 100.
দুখন কি কৰিলা? ইমান দূৰত থৈ দিছা যে? এইখিনি বস্তু, so Mr. Sharma,
Yes.
you have replaced that entire set of decisions by this new compilation.
Yes.
All these case laws which earlier you had given me.
Yes.
They are all now part of this.
Copies of that.
With me লাগিব, কাম কৰচোন। এই serial টাইমত সেইখিনি
Lordship, at page 105,
বুজি পাইছা? এই serial টাইমত in that compilation there is no citation given by you, Mr. Gogoi.
no.
এইখিনি এইটো মতে ঘূৰাই দিয়ক, কাৰণ মই তাত মাৰ্ক কৰা আছে। মই সেইখিনি চাম। যে serial টাইমটো মিলাই দিয়ক। পাৰিব? Yes, page
Page 105, Lordship.
one zero
5.
five.
It is, Lordship, for the procurements of goods and service. Oh, I'm sorry. Page 105. It is their affidavit annexure, Lordship.
Yes. Page 105.
Page 105,
This is-
annexure A.
Oh, I am holding the book. I thought you wanted.
Oh,
me
no,
to-
no. Books it is page 100 of the book. Page 100 of the book. It is the
Yes.
provision.
Government
And then,
GM.
Lordship, it is referred in the page 105.
Okay, 100.
100.
Yes.
It is the Roman 4, Lordship.
Yes, the state government.
The state government in finance department shall notify and the detailed guideline for such online procurement. This word such, Lordship.
Yes.
Lordship cannot read this two Roman 4 in isolation, Lordship. Because of this such word, Lordship, because this Roman 1, 2, and 3 is referred by this such. And Lordship will take my written argument. There I have given in the page 10. Page 10,
Yes.
C. Page 10, C.
Yes.
Subrule 4 under, I'm sorry.
Yes.
Subrule 4 under the OM has purportedly been framed, only empowered the state government to notify guidelines regarding such online procurement through JAM. The objective of such, which prefix the word online procurement through JAM, is submitted to indicate that the online procurement through JAM envisaged under this Rule 4 has to be read in the same sense as it is attributable to this word under the proceeding sub-rules, including the sub-rule 1, that is online procurement through JAM, which is subject to provisions of the Act 2017 Act. So, there I have given a small judgment, Lordship, because that in my Lordship, that is page 251, 281.
Yes.
281 is the judgment. 2000, I have given the copy
Yes,
to my
just give me the
learned friend.
citation.
280 and 2002, 4 SCC 539,
Yes, read. 531.
539.
Yes, so just read.
It is the para 8 at page 287, Lordship.
Yes.
Lordship, get it?
You read.
It is near Placitum C, Lordship.
Just read.
While dealing with the landlord failing in category 4, the legislature has consciously not used the word such member in the context of a relation. If the word would have been relation to such member, then the word member would have been taken the same color as has been given to the word member in category 2. By using the word a member in the word member should like a color different from the one envisaged a member and such member in category 2 and 3 respectively, as in our case, Lordship. Then
1, 3. What is it, no?
While. Let's see the EU code.
No, code issue. No, issue code. While.
While dealing with the category 4 and touching the subcategory A, the legislature once again was the expression a member of the naval, military or air force of the Union of India, and while passing on the subcategory B, prefix as the object is such, the noun member meaning thereby that in subcategory B, the member of to be read in the same sense as in the attributable to the category 4. In addition to the word such member is qualified by to die, who dies, or the sentence has been added in of this sentence has been added in 1979 amendment, a relation to so and so. So this is the thing, Lordship, the such Lordship to Lord cannot read in isolation, Lordship, this 4. That is what Lordship says. The provision interpreted is quoted in para 7 as in our case, Lordship, in the page 286. This is my case. I'm grateful, Lord.
Yes, Mr. Gogo, you wanted to say something?
Those 3 citations, my lord, I will just give
Yes, I was thinking of taking it while I'm dictating your submission.
Lordship.
Just keep it
Lordship.
while I record your submissions. You can
My lord.
give it. Mr. Sharma, I'm going to dictate the judgment.
Yes.
Let me see to what extent I can
Ye-
dictate
yes,
it in
yes.
court. I might dictate the later part inside, but if you have something else, then just ask
Well, the only
Mr.
thing-
Gautam, you be here while I'm dictating the facts. Huh. Yes, Mr. Sharma? সেইখিনি হৈ গ'ল কৰিলে ইয়াত দি দিয়ক
So that day I have argued, Lordship, that communication of reason is in section 26(3) is a facet of the principle of natural justice. That day I have placed the whole thing, Lordship.
yes you have given that 1.1
Yes.
your argument
Yes. Then judgment I have given in the 1 and 2, Lordship.
that you be here if unless you are required somewhere else, because while I'm recording your submissions, if
Lordship.
anything is to be both side, I'm saying
Lordship.
if you want anything to be added, I can add. Huh? Completely no ঠিক আছে তাহলে হেতু কৰি দিছে B. Gogoi, I think Mr. Gogoi, you had given one. Ramchandra this one was given by you. I don't know. I have it. Your name.
2007 to SCC, my lord.
2007 to
Yes,
SSC.
one that day I gave one.
To take it over.
There, my lord.
All right. I'll come to that.
Well,
एक ही यहाँ रुको ना. Are these the record?
no, the records are with me, my lord.
What was this?
This is that, my lord, the minutes of the, my lord, financial bill. As well as technical.
Let's see if we need anything from the record.
Right.
Yes. You ready? To record it on. Heard Mr. S. Sharma, learned senior counsel, assisted by Mr. A. Gautam, learned counsel for the petitioner. Also heard Mr. B. Gogoi, learned additional advocate general appearing for the state. Yes, you are also there. Along with Mr.
M. Bhuiyan, lord.
M. Bhuiyan, learned counsel, learned government counsel or standing counsel? Learned counsel. Stop. By way of this petition under Article 226 of the Constitution of India, comma, the petitioner is assailing the notice inviting for retender, within bracket e-tender, number MCH 2024-948, dated 9/1/2024, for providing annual job contract of dietary service to the patient admitted in Assam Medical College Hospital, Dibrugarh, issued by the Superintendent, Assam Medical College Hospital, Dibrugarh. The brief facts of the case is that pursuant to NIT dated why you have said 16, 10, 17? That is something else, no? This tender started from 3/10/23, correct?
Yes, Lordship. It is the earlier thing, Lordship.
Okay, that may not be. Mr. Gautam, okay, I got it.
It is from paragraph 5.
Five, I got it. Okay, look, no? Brief facts of the case we examine. That pursuant to a notice inviting for e-tender through e-procurement system for providing annual job contract of dietary services to the patient admitted in Assam Medical College Hospital, Dibrugarh, bearing number MCH 2023, it was stroke 25858, dated 3/10/2023, issued by the respondent number 4 and 5, comma diba, aru etar agot within bracket, herein after referred to as the first tender. Okay. The petitioner who is a government registered first class contractor and order supplier along with two other bidders participated. Though in the technical bid, the petitioner was qualified. However, the financial bid of the petitioner was not opened. Stop. It is the specific case of the petitioner that thereafter by notice inviting for retender, within bracket e-tender, through e-procurement system for providing annual job for providing the same services to the patient admitted in Assam Medical College Hospital, Dibrugarh, bearing number MCH 2023 stroke 29988, dated 16/11/2023, was issued by the respondent number 4 and 5, hereinafter referred to as the second retender. जो तुम्ही कोसला same service as that of the first tender. ठीक है? In the said tender process, 4 bidders, including the petitioner and pro forma respondent number 7, participated. However, the technical bids of all the bidders were having been rejected, comma, for the third time, another notice inviting for retender, within bracket e-tender, through e-procurement system for providing the same services as that of the first tender and second retender was issued by notice Vide number MCH 2024-948 dated 9/1/2024 by the respondent number 4 and 5, hereinafter referred to as the impugned third re-tender. Okay, egila monot thoba impugned third re. The petitioner having noted the aforesaid advertisement in the newspaper on 10/1/2024, participated in the said tender process, apart from the petitioner, the pro forma respondent number 7 also participated. The technical bids of the two bidders were opened, and upon being duly qualified, their financial bids were also opened. However, at that stage, however, though the petitioner was found to be the lowest bidder, however, the fourth tender was issued, not issued.
Yes.
Issued.
I have
Let me
annexed.
get the reference.
It is in the jam law.
For the fourth time, the where do I get the reference?
Para 13 and page 14.
Page 14.
Para 13. That's the gentle.
For the fourth time, notice inviting for retender of the same work, same services as that of the first tender.
It's not a retailer.
This is not a retender.
Was a fresh tender.
Tender will go back. Tender for the same work as that of the first tender, comma, second retender and the third impugned retender was issued in the portal of government e-market within bracket GEM by bid document number GEM/2024/B/4755482 dated 8/3/2024. Correct? That is
Yes.
aggrieved by the aforesaid issuance of fresh tender against the same service for which the petitioner was for which the petitioner had duly qualified as lowest tenderer, comma, the present writ petition has been filed. Stop. Mr. S. Sharma, Learned Senior Counsel, submits. Next paragraph. Till here, everything is okay? Till here?
Lowest tender part, my lord, there is no contention of the petitioner that he is the lowest.
Para
tender.
15 years. Para 15 years.
This, I am only giving the facts. Or situated does challenge के लिए लिखी दिया तुम्हारे underline. I'll simply say that. But that's an admitted fact.
Yes.
I will say it when I am going to say the facts.
Yes.
This is only, I have just dictated the facts in nutshell. It have arguments of Mr. Sharma. Huh? Mr. Sharma, then a senior counsel, appearing for the petitioner, submits that the manner in which the tender for the subject work has been retendered one after the other, despite there being participants and qualified technical bids, itself goes to show the arbitrariness involved in the decision-making process. He further submits that though the petitioner in the third retender was the lowest tender, the authorities, for reasons best known to them, instead of settling the tender with the petitioner, issued a fresh tender for the same work through GEM. He further submits that under the procurement rules, the authorities are bound to communicate the decision of cancelling the tender and reasons therefore to the petitioner.
It is Act and rules.
Act and rules, Procurement Act and rules, to the petitioner. And since the same has not been done, the respondent number 4 has acted in malafide and illegally. He further submits that communication of reasons is a facet of principles of natural justice. He further submits that it appears from the affidavit and subsequent documents placed by the state government that after the technical bids of the third retender was opened and scrutinized, the petitioner as well as the pro forma respondent number 7 were found to be qualified, and the tender committee had specifically taken the decision that since the two bidders have been found technically qualified and the tender has already been retendered thrice, to open the financial bid of the qualified tenderers. He further submits that accordingly the financial bid of the petitioner as well as the pro forma respondent number 7 were opened. However, instead of settling the tender with the petitioner who came out, whose bid was the lowest, the respondent authorities decided to issue fresh tender for the same work. He further submits that under the Procurement Act and rules, the decision for fresh for cancellation or for procuring or for issuance of fresh tender has to be made by the procuring authority, i.e. the respondent number 3 within 4 within bracket principal
Some chief
comes
superintendent.
chief superintendent
AMC.
AMC
AMC.
AMCH. However, it is clearly evident from the materials placed before this. However, it is clearly evident from the affidavit as well as the documents placed by the state government that the respondent number 4 has merely endorsed the decision of the tendering committee without any independent exercise and or application of mind as required under the statute. Stop. He further submits that it is also evident that the respondent number 4 in his affidavit in opposition filed before this court and in the additional affidavit filed during the course of the hearing has taken contradictory stand in support of the aforesaid submission, as regards communication of reasons, comma, he relies upon the following decisions of the apex court. Number 1, 1976, 1 SSC 1001. Number 2, 1993, 1 SSC 78. He further submits that the office memorandum dated which is this 24 January, you're talking about the 9th 120, no, 8/1/24 office memorandum in your, in this page 5 of your written argument. Is this poem you're referring to is 8/1?
Yes, yes. Where I've written January 2024
okay.
is the same one. Because
He
it's
further
middle of
submits
the-
that the office memorandum dated 8/1/2024 cannot override the provisions of the Act of the Procurement Act and the rules framed cannot overrule the rules and that the said office memorandum is not issued under sections 3, 4F, 28(2) or 58(1) of the provisions of the 2017 Act. Full stop. Actor naam tumar pise tumang di dim, huh? He further submits that the respondent authorities have not followed the provision of the aforesaid Procurement Act and rules while not accepting the lowest bid of the petitioner and thereafter and the issuance of fresh tender thereof. Accordingly, he submits that the decision of issuance of fresh tender for the same work is totally illegal and arbitrary. In support of his submission, that when power is provided to do a certain thing in a certain way, it should be done in that way or not at all, comma. He relies upon the following decisions. Number one, Najir Ahmed versus King Emperor, 1935-36, bracket or diba, 63 I 372. Number two, Deepak Babaria versus State of Gujarat, 2014, 3 SSC 502. In support of his submission that executive instructions cannot overwrite statutory provisions, he relies upon the following decisions. Number one, 2006 11 SSC 731 within bracket Roman 2. Aru 2013 volume 5 SSC 427. In support of his submission that filing of affidavit is not an empty formalities and contradictions contained therein cannot be left unexplained by the deponents, comma, he relies upon the following decisions. Number one, 2014 5 GLR 197 Guwahati High Court. Number two, 1996 2 GLR 473 within bracket Guwahati High Court. In support of his submission that I think, Mr. Sharma, by and large, this is your argument.
yes.
I will go in details of the rules and acts
Yes.
while I'm dealing with it. But in
This is,
sum and substance, this
Yes,
is your argument,
yes.
right? Per contra, Mr. B. Gogoi, learned additional Advocate General of the state, submits that, yes, submits that, where is the affidavit?
my face.
Submits that the authorities in view of the mandatory requirement of procuring supply of the subject tender through government GEM, cancel the third retender and issued the fresh tender for the subject work by by government
E-marketplace.
Government
E-marketplace.
e-market
Place.
place.
We didn't break it there.
within bracket GEM. Yeah. He submits that the aforesaid decision having been taken in terms of the mandatory requirement as issued under the executive instruction, under the office memorandum issued under the provision of the Procurement Act,
Dated 8/1/20.
dated 8/1/2024, comma, the same being in public interest, this court ought not interfere with the issuance of the fresh tender for the subject work. Correct?
Man,
Stop. Now, anything else?
regarding that,
Yes.
in the additional affidavit, we have placed that, my lord, the tender financial bid was open. But because my lord, the decision was taken to cancel it, it
He-
was not uploaded.
He further submits that though the financial bid of the selected bidders in
Technically
i.e. the petitioner and the performer respondent number 7 in the third e-tender were opened. However, in view of the decision of the tendering committee to not to go ahead and insist and instead to apply for and instead for for calling fresh tender through mandatory GEM requirement, comma, the respondent authorities did not upload the result of the financial bid in the portal. Stop. Yes, what decision you wanted to show? In support of his aforesaid submissions, he relies upon the following decision.
Lordship, I have
Number
given-
one, I think you had given one decision I have here.
This one give. But the book list I have given and the para also I have mentioned.
Give number one on there, 2007, volume 2, SSC 588.
Only 4, my lord.
Only 4.
Like
Number
compared to
2.
them, my lord.
See the rate you all are giving me the authorities. My whole idea was to finish this judgment by this half here itself, but it looks like I will have to do homework inside.
My lord, 2007 to SEC for the, my lord, to substantiate my argument that, my lord, because of the change of policy, that's the ZAM portal, we have taken the decision. For that part, my lord, change the
But
policy.
Give it together because I have already said that
Yes,
you have
yes,
done it as
sure.
per that.
Only my learned that in the same judgment lordship 2007 to SCC 5.
Mr. Sharma, now you take your seat.
It is the para 6.
Now you take your seat.
Page 60.
Otherwise, you're not getting this judgment. I'm telling you. You're right. 2007, volume 2, SSC 588. 2005, volume 6, SSC 138. 2007, volume 14, SSC 517. 2020, volume 16, SSC 489. Palla? Egita naam gita lekhi diba, ha? I'll put the contents later, Mr. Gogoi. I'll put the contents later.
Yes, sir.
I've given my prudent in my prudent consideration to the arguments advanced by the learned senior counsel as well as the learned advocate, additional advocate general of the state, and peruse the materials available on record. I have also considered the citations cited at the bar. It appears that for the subject work, i.e. annual job contract of dietary services to the patient admitted in Assam Medical College Hospital, Dibrugarh. Initially, 3 tenders were issued. First, on 3/10/2023. Second, retender on 16/11/2023. And thirdly, retender on 9/1/2024. It appears that though the, no, one second. It appears that explanation in your affidavit, the first 2 tenders, you said something, I
Yes.
remember in your affidavit, that page.
Page, my lord, para 4, page
Uh,
99.
Page 99.
The second para,
This is the affidavit in reply, sorry. Let me just,
page 99, running page number 99.
running page 99. Oh, yes, yes, yes. Now paragraph,
Para 4 and 11, madam. Three tenders, my lord, why they have been
Yes.
cancelled, it has been mentioned. In fact, 11 will be more clear, madam.
para 11.
Yes, madam.
Uh,
The second.
quick it appears that in respect of the first tender, there were 3 bidders who participated, and in the second time, and in the second retender, there were 4 bidders who participated, and in the third retender, there were 2 bidders who participated.
No, my lord, in the first tender, only one qualified. In the second.
No, I am saying participated. Your affidavit I am reading, Mr.
Yes.
Gogoi.
My lord, my lord.
Hmm.
Yes, yes.
It further appears that
11. I guess 11 was round again. Already have it.
in respect of the first tender, only one bid was found to be technically qualified. And therefore, it was suggested for retendering, and accordingly, according to a stop, huh? It further appears that in respect of the second retender, no bidders were found qualified, and therefore, for the third time, a retender had to be called for the subject work. Stop. The issue involved in this writ petition being non-selection of the petitioner despite being qualified and the lowest tenderer in the third retender, comma, I shall now look into the decision-making process as regards the third e-tender is concerned. Stop. It appears that in your first affidavit, you don't mention much about the third e-tender.
The third tender, my lord, the last ground in para 11, my lord, second para. In the third instance, only 2 bidders qualified, but JAM is mandatory and participation of fluency is required. The last 2 lines.
It appears that in the affidavit in opposition, it appears that in the affidavit in opposition filed by the respondent number 4 on 13/8/2024, it is averred that in the third instance, only 2 bidders qualified, but GM is mandatory and participation of more bidders is required. It further appears that except the aforesaid bold stand, nothing further is discernible from the affidavit in opposition filed by the respondent number 4. Now, it further appears that in support of the said stand, the respondent authorities have enclosed an office memorandum dated 8 January 2024, which reads as under, quote unquote, page 105. Reading of the aforesaid office memorandum, it appears that the stand of the state respondent is that since government e-marketplace within bracket GEM is made mandatory for all procuring entities for procurement of all goods and services that are available in GEM as per Rule 24.124 of Assam Public Procurement Rules 2020. Stop. Accordingly, the said impugned decision of fresh tender for the subject work was taken. Apt at this stage to refer to the provisions of the Assam Public Procurement Act 2017, hereinafter referred to as the Procurement Act, Section 2E defines e-procurement as the electronic process wherein the physical tendering activity is carried out online using the internet and associated technologies. Section 2Q defines notification as a notification published in the official gazette. Section 2R describes prescribed as prescribed by rules made under this act. Section 210, Roman Deb, defines procuring entity to mean an entity referred to in subsection 2 of section 3. I think definition only this, right? Any other? No.
No.
Section 3 reads as under. Now you give the entire section 3, quote unquote. Reading of section 3 of the aforesaid Act, Procurement Act, it is clear that procuring entity means any department of the state government or its attached or subordinate office, amongst others. We are only concerned with that, right? Only concerned with 2A, right? 2A. In this case, you are only concerned with 2A, isn't it? Procurement entity?
Not B, Lordship.
Huh?
But B.
2A, I think.
They said that B.
A, I think it will be A.
Department is also A, any department.
Yes, that I have said, amongst others, Stop. It further appears that under subsection 3 of section 3, the state government may, by notification, permit the procuring entities to carry out procurement financed under the assistance from the multilateral development banks, bilateral develop. This is not required, I think.
But it is 3-2A only.
Huh?
3-2A.
3?
2A.
That is only, isn't
Yes,
it?
it
But
covers all.
Correct. Nalage. Section 26 reads as under, quote unquote. Section 26 of the said of the Act so and so, which provides cancellation of the procurement process, reads as under. Okay? Reading of the aforesaid provision, it is clear that the procuring entity is empowered under the provisions of the Procurement Act so and so to cancel the procurement process. However, under subsection 3 of section 26, the decision of the procuring entity to cancel the procurement and reasons for such decision is required to be communicated to all bidders that participated in the procurement process immediately. Stop. Section 28 provides the methods of procurement, which reads as hereunder. Under subsection 1 of section 28, the methods of procurement inter alia are open competitive bidding, rate contract, or government e-market, within bracket GEM. Subsection 2 of section 28 provides that the state government may by notification declare adoption of electronic procurement as compulsory for different stages and types of procurement, and on such declaration, every requirement for written communication under this Act shall be deemed to have been satisfied if it were done by electronic means. What key Korea say, bro? So right now it is obstructing administration of justice. What is this going on? Right here. This contract admittedly is electronic procurement, isn't it?
Yes.
Admittedly, the instant procurement is by electronic procurement, by way of electronic procurement. Subsection 3 of section 28 further provides that in procuring a subject matter of procurement, every procuring entity shall follow the detailed procedure in respect of the relevant method of procurement as may be prescribed in the rules made under this Act. Section 29 and 36 of the Act, which provides open competitive bidding, which provide the, it is providing the manner, right? Which provides the manner in which the open competitive bidding and rate contract and government e-market GM is done, reads as under, quote unquote, kore diba. First quote or bhitor diba 29, section 29, tapsot and likhi diba. Next quote to under diba 36. Okay? Reading of the aforesaid, it appears that under the open competitive bidding, the bid is done in two stage, i.e. technical bid evaluation and financial bid. Two-stage will be in that, isn't it?
Yes.
Technical and financial bid.
No, two-stage bidding is not that.
Then,
Two-stage bidding is something else. It's again, right?
but anyway, this I don't think is necessary.
That one, there is no dispute regarding that.
Then you say.
Technical bid, financial bid.
এইটো এতিয়া একো ক'ব নালাগে হা এইখিনি মই পিছত এড কৰি দিম apt to refer to the procurement section 55 of the so and so provides the power of state government to make rules, which reads as hereunder. Reading of the aforesaid provision, it appears, it is clear that the state government has is empowered to make rules for providing the procedure in respect of various methods of procurement under section 28, and that if any other matter which is required to be prescribed by the state government for carrying out the provisions of this act. Stop. That apart, it appears that under section 56, the state government is also empowered to issue guidelines giving details of procedure or general forms or standard specifications and manuals required for giving effect to the provisions of this act and the rules made thereunder, and that all guidelines issued by a procuring entity under this section shall be laid as soon as may be after they are so made before the House of the State Legislature while it is in session for a period of not less than 14 days, which may comprise in one session or in two successive sessions, and if before the expiry of the session in which they are so laid or of the session immediately following, the House of the State Legislature makes any modification in any of such guidelines or resolves that any such guideline should not be made, such guideline shall thereafter have effect only in such modified form or of no effect. Full stop. Apt also to refer to the Assam Public Procurement Rules 2020, hereafter referred to as the Procurement Rules. Stop. I think only Rule 24.
Yeah.
Rule
23.
I have it. Rule 24 of the said rules reads as under, quote unquote.
Yeah.
Reading of the aforesaid rules, it appears that the procuring entity may choose different methods of procuring specified in subsection 1 of section 28 of the Act, if deemed more advantageous and appropriate after recording the specific reasons and circumstances in writing for so choosing in exception to the preferred methods, i.e. open competitive bidding method in terms of subsection 4 of section 29 of the Act. And that such specific reasons and circumstances shall be recorded in the case file and clearly noted in the procurement register, indicating the name and designation of the procurement entity making the decision. Subrule 2 of Rule 24 provides government e-marketplace, GEM, wherein,
Sub rule of I,
sorry,
under I.
Subrule 2 of
It's 24I.
of section 24I
Yes, ma'am.
of the rules provides provides that procurements through government e-marketplace GEM shall be subject to the prior sanction of the concerned compounding authority with reference to the relevant delegation of financial power rules in respect of the subject matter and value of the procurement, and that the state government in finance department shall notify the detailed guidelines for such online procurement through GEM together with the mode and procedure for making payments to the registered suppliers thereof, and may be also prescribe financial sealing or any other conditions for the purpose. Stop. That's all with the Act and Rules. Anything left out?
No.
Mr. Gautam, anything left out?
Only Roman 1. Madam.
Roman 1.
Our contention is Roman 1 and Roman 4 have to be read together. Because of the word subject to.
All right, all right. এই য'ত লিখিলা ফাৰ্ষ্টত all such procurements through GEM বুলি লিখিছিলা নহয় তাৰ আগত এইটো এড কৰি দিবা মই এডিটিঙত চাই দিম তুমি এটা জাষ্ট লিখি লোৱা that procuring entities in the interest of public and need in the interest of public বুলি কৈ দিয়ে in the larger interest of public may utilize the government e-marketplace within bracket GEM facility for purchase of their essential common use need determined as available therein, subject to the provisions of the Act, the guidelines that may be notified in this regard by the state government, and without exception, the condition that the rates for the items offered by suppliers, the GEM, or the total cost involved thereof are not higher than the prevailing wholesale market prices in the state or the discounted rates of authorized dealers in the state or applicable. Stop. What transpires from the above is that under the Procurement Act and rules, the state government in the larger public interest has the power to procure procure essential common use needs through the government e-marketplace within bracket GEM. However, the decision of availing the facility of government e-marketplace for purchase of such essential services and commodities, comma, the state government is bound by the provisions of the Procurement Act, rules and the guidelines that may be notified in this regard. And that all such procurements through GM and that all such procurements through GM shall be subject to the prior sanction of the concerned compounding authority, and also the state government in finance department is required to notify the detailed guidelines for such online procurement through GEM together with the mode and procedure. Notify. Stop. Turning back to the facts of the instant case. Yes, where is that technical bit where that noting is? In some of your additional reply. Where was that? In the record or where?
That compilation, my lord.
Oh, yes, it's in the compilation.
The compilation loss.
Now you understand why I'm dictating this in the open code. Otherwise, Mr. Sharma, it's a nightmare inside. No assistance.
I know.
All alone. It is a nightmare.
Yes.
Yes.
Yes, page number 1, my lord, Lordship will say
Page
this is the
number?
first one of the compilation.
No, I don't want the first enter.
Third one,
Third one. Yes, I've got it.
Page 11.
I've got it. I've got it.
11
I have got it.
down below.
This is there in your record, now.
Yes, it's there in the report.
Turning back to the facts of the case, it appears from the records pertaining to the subject tender made available to the court by the learned additional advocate general that the tender committee in their minutes of the tender financial bid opening meeting held on 22/2024 was of the opinion, were of the opinion that since there were only 2 bidders participating in the process, to have a better participation and involvement of more numbers of bidders to ensure the quality comma, the committee members recommended the respondent number 4 to float a fresh tender through GEM portal. It appears that a perusal of the since it was not clear as whether the since that admittedly, the respondent number 4 is the procuring entity in the instant matter, in the instant subject matter. And in order to ascertain whether the procurement entity, i.e. respondent number 4, who is the competent authority under the provisions of the Procurement Act, has taken a decision to cancel the third retender, or not, comma, the state government was directed to file an additional affidavit. Correct? This much is correct? Mr. Gautam, it's correctly said, no?
Yes, yes.
Because of that only.
Yes.
Stop. In compliance with the court's order, an additional affidavit has been filed. Look, affidavit on today's date.
Yes, on today's date.
On so and so, wherein a letter issued by the respondent number 4 and respondent number, superintendent is respondent number?
Four. Superintendent is 4. Tender committee is 6 minutes.
No, this principal come chief.
These are 4, respondent 4.
And who is superintendent?
He is respondent number 4. The superintendent.
I think it's 3.
No, he is below.
5.
5.
4 and
5.
And R5. Huh? Respondent number 4 and R5. Letter
4 is the
written-
chief superintendent.
But he is the authority, isn't it?
He is the authority, yes, sir.
R4 and R5, huh? Issued letter dated 25/4 so and so. Yes, please. By R4 and R5, huh? Stop. Which reads as under A to A, page 185 to DD. Take a sir. Reading of the aforesaid letter, it is clear that in terms of the minutes of the tender financial bid, no, in view of the government, it is clear that according to the minutes of the tender financial bid, comma, although the financial bid was opened through online mode, however, it was not signed and endorsed by any members of the tender committee. It is further clear that in view of the office memorandum dated 8/1/2024, since the committee members recommended the respondent number 4 to float a fresh tender in the subject tender in relation to the subject work through GEM portal, comma, the matter was referred for fresh tender under GEM portal. And the financial bid of the 2 selected bidders were not uploaded / submitted in Assam tender portal. it is further clear from the this is what is this annexure, because you have not referred to this, that rates you have given. This document which you showed
Yes,
at page 1,
my lord, this is part of the, my lord, that letter of the superintendent.
it is further apparent, it is further clear from the enclosure, from the enclosures,
Can you speak for them? We have control the letter.
from the documents enclosed to the aforesaid letter dated 25/4/2025,
Yes,
that the petitioner was the lowest. The petitioner offered the lowest rate, na?
Lowest financial bill.
Lowest financial rate. That's the wording, correct?
Yes, yes.
financial beat, my lord.
Financial
Yes,
bid.
financial.
Lowest financial bid. Stop. I'll come back to this affidavit of piece of, huh? It is thus apparent that the decision of the authority not to accept the financial bid of the petition, or no, not to finalize the third e-tender after the opening of the financial bid, despite the petitioner having offered the lowest financial bid, was in view of the office memorandum dated 8/1/2023, 2024, which mandated procurement in respect of the subject item through government e-market to লিখি দেব আৰু GM by way of stop facility. Okay? As stated above, in order for an office memorandum issued under the Procurement Act to come into force, it is condition precedent that the office memorandum is published in the official gazette as mandated. Bas, full stop. It appears that the office memorandum dated 8/1/2024 is not been published in the official gazette till date. However, the state respondents in the said additional affidavit has enclosed a notification dated 28 January 2022 to contend before this court that the office memorandum dated 28/1/2022 mandating government e-market GM mandatory for all procuring entities for procurement of all goods and services that are available in GEM has been published in the official gazette on 1/3/2022. The aforesaid stand of the state respondent appears to be totally fallacious, inasmuch as the office memorandum dated 8/1/2024, page
105.
in Poisan is fallacious inasmuch as in the office memorandum dated 8/1/2024, comma, it is specifically mentioned that the GM notification dated 28 January 2022 stands superseded.
Yes, yes. Yes, 10th word.
In view of the issuance of the office memorandum dated 8/1/2024. Stop. Even. I think more or less the factual aspects I have covered. So I'm fixing it on Thursday. Most likely you will have the entire order ready on Thursday. Just not closing it today because you don't know something there could be. So it to put it a draft to beleke kori diba, aru muk di diba draft and to be like hard hearing complete no, further hearing Thursday date to detail. I think now I have to just deal with the case laws. Mr. Gogoi, your records, you just give it to him. Record case video. Look.
I'm obliged, my lord, it's a patience hearing lordship. After a long time, lordship, it's a long hearing lordship.
Which was this matter for supplementary?
My lord, my lord, my learned friend has filed an IA. Definitely, he has a right to file. He will start, my lord, his IA, and
The stay vacating.
If there was a stay which was extended, it is his prerogative to file an IA, my lord. He is the private respondent. But before that, I will say, my lord, that there will be certain issues which will have to be addressed. The main action challenge was, lordship, I will take your lordship to the order first. Not that I am shying away from his IA. I am just pointing out the interim order. And there will be certain questions which will be and matters of interpretations which will be there even for the purpose of disposing of this.
You mean to say the entire matter needs to be heard?
My lord, it's the same length, at least my lord, same
My
length.
lord, I shall place, my lord.
What is the issue?
My lord,
Mr.
here what
Saiwala?
happened, my lord, I'm submitting it.
No, product, my lord, the lordship may see the order first.
I will, Mr.
This
Putnam,
order,
just
which
have your
order he
seat.
has come for vacating, my
Yes,
lord.
have your seat.
Then he start.
Yes,
I'm
Mr.
coming,
Saiwala.
I'm coming to that, my lord. Now, first, my lord, what
No,
happened? I have filed an application for granting an NOC for establishment of petrol pump. My lord, petitioner number 2 filed an objection, my lord, there. Then the matter was heard by the deputy commissioner. And my lord, thereafter the NOC was granted on 15/7/22.
NOC
that
was
your-
granted to you.
15/7/22.
15/7/22.
7/22. First
Okay.
NOC that for establishment of petrol market. My lord, now what happened? Immediately thereafter, we have, my lord, started construction and obtained, my lord, various formalities you have to do, my lord, fire, other things, my lord, trade license, everything I've annexed. Then, my lord, this writ application is filed almost after
Pranam.
about,
Pranam.
almost about after 3 years, my lord.
One second. Sorry.
My lord, yes. Now, almost about 3 years, by which time, my lord, my construction of depot is complete. My lord, just your losses, my lord, may see the photographs at page 72 of my IA.
All right, I'll go to the photographs, but first, where is that order?
Yes.
Again, which
Yes,
way,
that order is
dictation
at
of
page,
which-
my lord, your losses may come to page 22. Para 3, my lord. It is a case of petitioner that no objection certificate that the 57/22 has been issued in violation of the guidelines issued by the Central Pollution Control Board by office memorandum so and so, wherein it is provided in case of sitting,
NOC is issued by whom?
my lord, NOC is issued by the deputy commissioner.
By Deputy Commissioner.
Deputy commissioner, district magistrate.
Yes.
So the last sentence is important, my lord. Residential area designated by local laws shall be less than 30 meters. My lord, there is no hospital or other things, my lord. Here,
Petitioner is Mr. Barbara.
yes, my lord, Barbara, my lord, what happened, my lord, their house is within 30 kilometers, 30 meters, but my lord, it was not a residential plot. At that time, my lord, it was a agricultural plot. My lord, it must be as per the local laws, my lord. So, my lord, the NOC has been granted, and this honorable court passed an order. If you also see at page 24, my lord, what order has been passed?
Just let us read this entire order.
Yes,
Paragraph 3 starts from
my
paragraph.
lord, paragraph 3, I said. Paragraph 3 onwards, my lord. It's a case to petitioner that no objection certificate that so and so has been issued in violation of the guidelines issued by the Central Pollution Control Board Assam by office memorandum number so and so, particularly with reference to clause 8, wherein it is provided that in case of sitting criteria for petrol pump, new retail outlets shall not be located within a radial distance of 50 meters from the fill point dispensing unit, van pipe, which were nearest from the school, hospital, and residential area designated by local law. It is also provided in case of constraints in providing 50 meters distance, the retail outlets shall implement additional safety measures as prescribed by PESO. In no case, distance between the retail outlet from the schools, hospitals, and residential area designated by local laws shall be less than 30 meters. The further case of the petitioner is that when they saw some development adjacent to their residential building, they made an inquiry and thereafter submitted a complaint before the Deputy Commissioner Nagaon, the district on 17/1/22, and also before the Joint Controller of Explosive, Petroleum and Explosive Safety Organization, Guwahati Circle, on so and so. Thereafter, the Circle Officer, Deha Division Circle, submitted a report in connection with the setting of a new petroleum RO at Sapormukh, Gaon, before the Additional District Magistrate Administrative Branch, Nagaon, on 18/6/22, wherein it stated that no school, hospital, at the distance of 30 meters or 50 meters from the site selected for setting up the petrol pump, fill point, dispensing unit, van pipe. However, with regard to distance between the south of the land of the petitioner and the petrol pump unit, he mentioned that the fill point Jogeshwar Bora house is approximately 12.81 meter. Dispensing unit of Jogeshwar Bora house is so and so, and van pipe of Jogeshwar Bora house is 7.80. There is no HT line, electric line over the site selected for the petrol pump. It is therefore the case of petitioner that view of the report of Circle Officer, Rahat Division Circle, dated so and so, Deputy Commissioner, Nagaon could not have issued the no objection certificate for storage of petrol products near the premises of the petitioner. Issue notice so and so, then my lord, say, please take step for service of notice. Then your lordship may come to page 24.
1 second.
Till next return will let status quo as on today shall be maintained by the party with regard to construction of a petrol pump. So construction is already complete, my lord, before the passing of the order. Construction is
But
already
what
complete,
happened on the returnable date?
my lord.
On the returnable date?
Returnable date 4 weeks, my lord, but
4 weeks has not expired.
my lord,
4 weeks have expired or not expired?
that was expired on the last occasion that took time, my lord, they got it extended, my lord.
Where you did not appear.
Well, I appeared.
Why you did not place all this? Because
Well,
this
I
interim
could not
order.
get the chance, my lord. They wanted to file an objection to it.
Huh?
They wanted to file an affidavit to this.
No, no.
No,
we
no, no,
filed
no.
An objection, then next day, they said we want to file a reply to that also. There were a
No,
number of pleadings.
1 second, Mr. Barbara. Mr. Sahewala, what I'm asking
Yes.
you is, because this order of which vacation you are seeking,
Yes,
here it was only till the next returnable date.
correct.
Status quo as on today shall be maintained,
My lord.
correct? And this is only as regards to the construction of the petrol pump in question. Now, on the returnable date, you had appeared.
Well, not only it on the, before I think it is, my lord, it was,
When was the returnable
4/5/25, my lord. Yes, on that day, my lord, they.
4/5?
14/5/25.
14/5/25, you had appeared?
Yes, my lord. I appeared, my lord. I wanted to press it. They prayed for time,
Press what?
my lord.
That day you filed this IA.
They prayed for time to file an affidavit.
Because,
We filed additional affidavit.
now here the prayer is for not extension or prayer is for vacation.
Vacation, my lord, this is vacation.
That is where what I was trying to impress upon you is that since it is not a absolute this
Yes.
interim is only to a
Well,
particular date, you could have appeared on date and simply shown
Yes,
that the construction is already over.
yes, not such.
Then the court would have not extended the interim order. Now,
Yes.
where is that order of extension?
My lord, the 14/5, my
In the
lord.
I-
Where is it? Yes.
The I,
Where?
I.
Page?
I number.
No, I have
No,
the IA.
Not here, my lord. That is in the record, my lord.
No, but that has to be given.
138.
Why have you not enclosed it?
My lord.
That is not enclosed here.
No, prior to that, we filed this petition, my lord. On that day, I am, my lord, when listed.
Sound, main read to sound.
I number 138.
When. we
That
filed-
IA is in front of me, but this is WPC.
Up to 25/4/25, we filed, my lord.
No, that order is not here.
In the IA, this what I said.
Oh, in the IA it has been. Sorry. You took time to file written objection.
Yes.
Mr. Sahewala, learned counsel for the applicant is granted 2 weeks time to file reply affidavit.
Yes.
And on 2/5/25, you had
Some time to file.
affidavit and interim order was
Again,
continued.
file the reply. The last-
Pleadings are complete.
It is
Not the
a-
official respondent, the
No,
deputy
it is not-
commissioner has not come with any reply.
No, it
Where is the
not-
deputy?
I
commissioner?
basically
Mr. Das,
challenge her order,
what is your instruction?
no affidavit.
Because challenge is that it is between 30 meters. So our construction means that single house is not only eastern, that means that house of the.
My house,
Is there within the distance? Within the?
30 meters.
30 meters.
So there has to be, there cannot be any residential house in between 30 meters.
Within 30 meters, so
Within 30
if it is hospital, within 30 meters, if it is house, there is a house, dwelling house, It should be
Where is
below,
that requirement?
below 30.
Where do I get that requirement?
Petroleum rules.
Mr. Smith, just
Annex of 7 in the main
put
read.
it in your
My lord, next time, my lord,
video, video flag for it.
in the main deed, it is there, my lord. If your losses takes
All
up.
right, all right, all right. What is it?
Page 27 of the resolution quoted. Page 30.
Designated residence. Particular part is, my lord, 32 page. Particular part is at 32 of the repetition.
One second.
32 of my
One
resolution.
second, one second. Let me read the parawise first.
Yes.
Proceeds.
Only one house. That will be more than 30 meters around. 30 meters, not 50 meters. Can be less than 30 meters. This is also to 50 meters. No. Let us come here. 50 more complicated. It will be designated residential.
This, so according to you, this permission NOC is legal or illegal? There is a house.
The house is, that should be the integrated residential area. That should be in the designated residential area. Now, at that time, it was the agricultural land.
Mr. Saiwala, now the matter has to be heard.
Yes.
We are only seeing if prima facie the petitioner has made out a case for interim or not,
No,
because
my lord, here I-
war against vacation of the interim.
My lord,
Where is the requirement?
if your lordship will see, my lord, at page 32 of the resolution.
Page 26 of the resolution quoted H, clause H.
Clause H is at page 32.
Page 32.
32.
In
There
a
was
case of, yes, Mr. Sawala, you may please read it.
Yes, page 32, clause H. In case of sitting criteria, petrol pump retail outlet shall not be located within radial distance 50 meters on the dispensing unit, van pipe, whichever nearest from schools, hospitals, and residential area designated by local law. In case of constraints in providing 50 meter distance, the retail outlet shall implement additional safety measures as prescribed by PESO.
So here apparently within 50 meters there is a house.
No, well, that should be residential area designated as per local law.
Now we don't know all that.
Well, I'm coming back to
You
that.
see, the affidavits have to be filed.
No, yes, well, I've come. Well, here what happened?
Where are you showing that this is not a designated?
Well, it was the agriculture area. They have converted it in 2024, my lord. I've annexed it.
Prospecto.
Prospect. Well, your
Where,
losses.
where?
75. Page 75, your losses may see. That was converted to residential in 2024, my lord. Thereafter they came here. Well, after 3 years, that is why this is money.
Yes.
When was this issued? Page 75 document?
Yes, my lord, last one, my lord, 4/1/24. 124. My lord, the class of land is changed from cultivable to first class residential.
You're referring to this chart?
My lord?
This chart?
Yes, it's right hand column. Right hand.
As per order of so-and-so 27/3/2022.
The second part of the order.
Partition case number so-and-so. The name of so-and-so is mutated in respect of land so-and-so as separate Meadi Patta is created with dag number so-and-so, registration deed so-and-so.
Second part, my lord, the
As per
class.
earlier order Land is changed from cultivable to first class residential
Yes, this is on
by
4/1/24.
Deputy Commissioner dated 4/1/24.
On 4/1.
And this NOC is dated 22
Se-
something.
27/5/50.
Yes, what is your response to
My lord.
75, Mr. Barbara?
And
And your construction is complete?
my lord,
Construction?
yes,
Which document?
absolutely complete, my lord. It
Which
is
document you were referring to some
my lord, page
photographs?
72, your lordship may see, my lord. Photographs I have given. Everything complete, my lord. We have to start it, then only, my lord, they have approached this honorable court. Page 72, 73, 74. Everything is complete. And what they have given, my lord, for the delay, that your losses will just come to one paragraph, my lord.
Mr. Barbara, in your writ petition, the only ground is about this residential area.
My lord,
Yes.
my lord, looking at this certain developments, immediately I go to the deputy commissioner and file a complaint that some construction, preliminary construction regarding setting up of a petrol pump is going on. It will create health hazard, my old parents and everything. And guidelines already your lordship has seen. Clause H, that is mandatory. Supreme Court has said, National Green Tribunal has said, that is mandatory if there is a house
In
within
the
the
designated land.
designated land, then within 30 meters. This is the boundary wall. That would have to be beyond 30 meters. And the deputy
But there is an important issue that has just cropped up.
cropped up.
Whether that land was initially a cultivable land.
I'll show you.
So if it was a cultivable land in the year 2022, then the NOC there is nothing
No,
wrong.
I have been staying there for long 10 years, more than a decade. I have a
No, but
certificate.
this, what about this document? This is the government document.
Let me put it this way slightly, my lord. Lordship may see my.
You see,
objection and-
because Mr. Barbara, you may be right. This person may be having a house there from long years.
Yes.
However, if that time the purpose of land is not is for cultivable and he had illegally constructed a house,
Right.
now that will not be under clause H. That is not going to be a bar for issuance of an NOC.
No, on my-
Correct.
right.
But with this document now, if suppose after 4/1/2024 somebody wants to apply for an NOC, perhaps clause H will come in.
No. That's
But not prior to
no,
4/1/2024.
no. The impugn order by the
This is the
NOC.
case, right?
My lord. And another aspect, my lord, you also
I'll
see
reply.
paragraph 19 of the writ petition.
What is that?
My lord, that he says,
I think this matter can be heard. I can fix it on Thursday. We'll take up it for final hearing. There is nothing more to be heard in this matter. The whole issue crops
Well-
is on that state.
Uh,
You file your affidavit Thursday.
And
You have the para-wise, Ms. Das.
this is Ketia.
So you file it.
Thursday মানে এই সব Thursday কথা কৈছে।
No, can go to Thursday.
Or you call him to the office of the additional senior government advocate. Mr. Gogoi is here. He will ensure that the district commissioner, whoever from Nagaon, will come and sign it in your office. You don't have to send it for signature to Nagaon.
Well, just
Mr.
one,
Gogoi,
just one,
I'm sure you can make use of your good office.
only one thing I want, Lordship, on my complaint, I was called for a personal hearing.
Very well, we will hear the whole matter.
Whole matter, my lord. Only thing, my lord, this Thursday, I'll be in Onachal.
Next Tuesday?
Next Tuesday, all right.
Next Tuesday,
Next
Mr.
Tuesday.
Sahewala? I'm fixing it for hearing. You will file your affidavit by when? You file it by Thursday, because I want this affidavit by Thursday so that on Tuesday, nobody takes time to file anything. I'll make sure, otherwise, whoever wants time on that date, suppose it is Mr. Barbara, you want time, then the interim will not be extended. I'm making it clear.
After the deputy commissioner files his affidavit, I'll need only 3 days to give a reply affidavit.
Right, she's filing it on Thursday.
And by the way, in the main case,
She's
they have,
filing it on Thursday.
By Monday.
then Tuesday is all.
And your affidavit in the main case, you can convert
yes,
this.
I can take.
Mr. Barbara, I think the reply affidavit The IA can be treated as an affidavit in the main case. You have already filed your reply.
Right, right.
So,
No,
you see, no point in keeping
no,
this
it
matter.
is his business.
The interim, you want an interim, he doesn't want an interim. This court is ready to finally settle the issue.
That's right. That's right, my lord. And
I think it will be good for all.
good for all. That's what initially I wanted to say, my lord. The deputy commissioner is the main answering respondent.
They have given the para-wise, but you see, this has some important bearing.
Yes.
This has an important bearing in the matter.
Yes.
Therefore, let this come by way of an.
And he has not mentioned in the NOC that he ordered the circle officer to conduct a field survey with the Lat Mondal, and he submitted a report. There is no
You
whisper about
have
it.
records also.
Records will be
You
necessary.
can get the records. All right.
Thursday reply delay.
Lay and-
Just I am consulting the minor date. If they at all file by next Thursday, if it
This Thursday.
the-
They are filing it this Thursday, Mr. Barbara.
Lord-
Government is
Lordship, my lord, then my lord,
very.
on 12th, give me 3 days to file. Next Thursday means
Huh?
next Thursday. Next Thursday.
This Thursday they are filing.
Next Thursday.
Day after tomorrow. And I'm taking up the matter on Tuesday. You file your affidavit on Monday.
Tuesday means 10.
Yes.
If a little bit of time is
No further time.
all right, all right.
You already know there's 10. This is the para-wise comment. Ms. Das, give a photocopy to Mr. Barbara. Mr. Smith, you can have your skeleton draft ready and get it settled by Mr. Barbara. Yes.
So Lordship will have got final hearing.
Yes. What is there to finally hear? This is the facts.
That's what
But
initially.
I could have disposed of it today, but I want the affidavit of the district magistrate on record.
Yes, right.
Because this matter can travel far.
Yes.
So let us have the
My lord.
affidavits on record.
And if why we delayed, we had to
Uh,
obtain it through RTI. We didn't know. Even
This is
the
all on record. So you make your final arguments on that day.
yes.
Save your energies for the final hearing.
Lordship.
Heard Mr. G.N. Sahewala, learned senior counsel, assisted by Mr. M. Sahewala, learned counsel for the applicant. Also heard Mr. A.C. Barbara, learned senior counsel, assisted by Mr. M. Smith, learned counsel for the respondent number.
Opposite party number 1 and 2.
Respondent number
Wait, wait.
1 and 2.
Opposite party
stroke.
number I.
Huh? Opposite.
And we are it petition.
Opposite party number 1 and 2 stroke petitioner and MSU Das, learned additional senior government counsel for the state respondent. You are also there. Pollution.
Yes.
Mr. S. Burwal, learned standing counsel, pollution. Okay. This interlocutory application has been filed for vacating the order, vacating the interim order passed earlier by this court by order dated 1/4/2025 in the connected writ petition IWPC 1805 of 2025. The issue involved in this writ petition, in the writ petition is as regards the NOC issued
Page.
by the district magistrate by order dated
NOC.
by order dated NOC order dated
Page 62. Page.
no the date
15/7/22.
15/7/2022 in respect of the petrol pump
Setting up a new.
setting
petrol-
up of new petrol pump by the applicant stroke respondent private respondent. In the MSU Das, learned additional senior government counsel, has placed the parawise comments which indicates that the ground based on which the interim order was granted, namely that there is a residential complex within the specific prohibited area, comma, appears to be I'll edit this sentence. It appears that how did I say? from wherein it appears that within the stipulated prohibited area for setting up of the petrol pump, there exists a residential house. Stop. Mr. G.N. Sahiwala, learned senior counsel, in response to the aforesaid parawise comments, submits that initially the land at the time when the NOC was granted was a cultivable land, which has been subsequently by order dated 4/1/2024 has been changed to residential class. Stop. It appears that in order to decide the interlocutory application for vacating the interim order stroke not extending the interim order further, the entire issue can be taken up for final disposal in view of the fact that the applicant stroke private respondent has already given its stand by way of the interlocutory application, against which the petitioner stroke opposite party has also replied. MS Udas has also assured that the parawise comments shall be placed by way of an affidavit
On behalf of respondent number two.
positively by 5/6/2024, 2025. The writ petitioner stroke opposite party is at liberty to file any reply stroke rejoinder to the said affidavit if they are so advised. Relist for final hearing.
Admission, my lord. Admission hearing. Admission
All
hearing.
right, relist for hearing, relist for here, for take relist on such and such date. Yes, date
10th of June.
10th
of June.
10 so and so for final disposal at the admission stage as consented by all the learned counsels appearing for the parties.
Right. Her
Correct,
affidavit will be,
petition?
yes, her affidavit on behalf of respondent number 2, Deputy Commissioner.
R2, huh? MS Udas R2 affidavit. You take back your parawise, give a copy to Mr. Smith. Mr.
Interim,
Smith,
sir,
this is the affidavit that will come, so you can,
interim to continue till then.
interim shall continue till the next date of listing.
Lordship.
It is needless to be clarifying that with the understanding the matter can be finally disposed of on so and so date, the IA for vacating the interim order has not been taken up today, has been postponed.
Lordship.
Itu teoretically, you does.
How large?
Yes, Mr. Gogoi, blacklisting.
My,
You have filed something.
no, my lord, I was supposed to place from the record, whether that, my lord.
Watch that filing. When I saw you, I suddenly remembered
Yes.
there was a mention in the morning calling for something.
That was.
That
with
was
earlier
item
case,
4.
earlier case.
Yes.
My lord, on the last occasion, the petitioner referred to a letter which the petitioner submitted seeking extension of time for further 15 days. The honorable court has asked me, my lord, whether that was considered or not. Lordship may kindly turn to page 95. Page 95.
Yes.
Well, this is a representation of dated 10 to 2025. There in the next page, in the, they have stated that, my lord, there's some, my lord, problem that they are facing with the transporter in transportation of the medicine.
Just
As a result,
read.
with reference to the subject cited above, we would like to inform you that due to the transportation mistake, the material was not delivered in time, but now the goods have already been dispatched and will be delivered to their destination shortly. We thus request you to kindly extend the delivery period by another 15 days as a special case. We do assure you that all materials will be delivered within the extended delivery period. Looking forward, so and so. Now, my lord, they say that, my lord, pursuant to this email at page 94, this representation was submitted.
Yes. No, because you see, at page 95, the reference are all there.
No, why I'm saying is, lord,
No,
see page 94.
No, you
Yes.
come to 95.
My lord.
95 is the reference
Yes,
orders.
yes, yes,
There's all these contract orders are there,
yes,
right? 19. Now, if you come to 94,
yes,
94 is in relation to this only.
yes, my lord. That's why I'm saying, my lord.
Letters
No,
submitted
why
to
we had to issue this particular email, my lord? That one I want to place, my lord.
Hmm.
Lordship may kindly say that.
Yes, this one.
Lordship may, yes. Now Lordship may kindly have a look at the first page. It is dated 10 to 2025. This is addressed to the mission director issued by the petitioner.
Mhm.
Here, my lord, they sought for 15 days time. Against this particular, Lordship will see the reference, my lord. In a very disarray manner, my lord, the procurement, the purchase orders were, my lord, mentioned in the top, my lord.
These are not the same 19.
No, in a disarray, my lord, disoriented manner, when they have, my lord, mentioned the purchase orders in that page, my lord. No, the one I have furnished, my lord.
Yes, I know.
So, my lord, the NHM, my lord, therefore issued the email in the page 94. This particular letter is not a part of the petition. They ought to have annexed it, my lord.
So, by why there are two of the same date?
No, Lordship will see, my lord. After receiving this particular, my lord, letter, we issued a email at page 94 stating that, Lordship will see, with reference to your letter submitted on 10 to 2025, requesting for extension of delivery period from your end for 25 numbers of POs without mentioning the item details, whereas the CDD and time with highest financial penalty at the rate of 2% per week.
Yes.
So and so has already been over, and also the extended delivery period has over. Therefore, as directed, I am to inform you that against every POs, that is purchase orders, for which you have requested for extension should also include the item name and tentative date of supply from your end. So we want to ascertain, just give us the details.
I think, Mr. Sahewala, you have not been briefed
Yes,
properly in this matter.
This particular, my lord,
After that, my lord, we have given the detail.
that's a different
Page
detail.
95.
No. But you see,
11.
for this, I think this matter is again taken up for consideration of interim today,
Yes.
right? Now,
My lord,
you see why yesterday I was with you is that reading of this, it was apparent that they have not extended, which they said in page 94 that you give,
Yes.
right? But now it appears that I was of the impression that this came and then referring to this
Yes.
10 to
95.
this letter of 10 to was
Yes, my
given.
lord. Yes.
Because yesterday, this is how the facts were projected before this court,
Yes.
right? However, Mr. Gogoi has pulled out this letter from the record.
No, that letter, my lord, that.
Where have you mentioned about
Yes.
this letter?
No, that is mentioned in the 94, my lord, page 94.
Where?
That is mentioned in page 94.
Enclosed in 94?
Yes, that is mentioned, my lord. With reference to your letter submitted on 10 to 25, requesting for extension of delivery
No,
period.
this 10 to 25 that
Yes.
you are referring to Annexure 5
Yes.
is the one at
No,
95.
this one, my lord. This one.
95.
Yes, my lord, no, not 95. 95
Then-
is subsequent. After
But
94.
where have you said that in your pleadings, Mr. Sahewala?
No, readings we have said, my lord.
Where? Show me.
Para 6.
Show me.
Para
Because
6.
you,
Page 10.
this is a writ jurisdiction.
Yes, my lord, para
Yes.
6, page 10.
Para 6.
Yes.
Yes.
Yes. My lord, the petitioner company states that since the purchase orders were issued at different point of time, the date of completion of purchase orders varied. In the month of February 25, the petitioner company started facing constant problems from the transporter, which had led to delay in delivery, and such delay was not in the hands of the petitioner company. As such, petitioner company by later dated so 10 to 25 paid for extension in respect of 25 number of pending purchase orders due to the issue of the transporter. by the said letter, it was informed that the goods are already dispatched, and however, official respondent number 3 stated that purchase orders were not mentioned without its description, and highest financial penalty period was already over. As such, asked the petitioner company to resubmit the extension request by the next day, mentioning the item descriptions. This was, my lord. And accordingly, the petitioner company immediately submitted a letter dated 10/2/25 regarding extension of delivery period to further 15 days.
Okay, all right, all right, all right. Now, what did you do after that?
Yes, now, my lord, after that, my lord, after considering everything, why I'm saying is, my lord, lordship may kindly turn to, it's a part of the so-called page 99 for a moment, my lord. My lord, in page 95, 19 orders have been, my lord, mentioned in their letter.
Yes.
The page, my lord, 95, these
Yes.
purchase orders, total 19. Just lordship may see serial number 4 at page 99. It's part of that, my lord, start in page 95.
Yes.
It is, my lord, the medicine has been mentioned in the first part.
Yes.
Then it is agron, that is a petitioner. The purchase order number has been given.
Yes.
The approved date means the date when the purchase order was issued, that is 23/9/2024.
Yes.
So delivery days is, my lord, from the date of purchase order is 75 days.
Yes.
Scheduled date of delivery, so it goes to 6/12/2024.
Yes.
This is the quantity, is number is this.
Yes.
Now, lordship will see. The petitioner could deliver only 88.4%, 47% after 147 days. Whereas the, my lord, period is 75 days, which can further be extended to another 35 days. At max, my lord, 110 days.
Now, 105 is the final order, na?
My lord.
Where this is dated? The impugn order is dated
My lord, impugn is, my lord, 10/3.
10/3/2025.
10/3/2025.
So after a month.
More than a month.
No, 10/2 is their extension and
Yes.
10/3
Yes, after
after a month.
Month.
And you wanted extension of how many months?
15 days, my lord.
15 days.
15 days.
But you have not done anything. You have not even extended.
No, my lord, moment the application is submitted doesn't mean that we are bound to extend it.
But where have you rejected?
No, question of rejection doesn't arise every time, my lord. He will give a representation.
Sorry, Mr. Gogoi.
No, I will produce the record, my lord. Lordship will see, my lord.
But
No,
you
no.
see, Mr. Gogoi,
My lord will
your-
see.
Your
Oh,
document at 94.
my lord.
Page
You have
94.
said, therefore, as directed, I have to inform you that against every so and so, you have requested for extension should also include so and so. Kindly resubmit your extension request by tomorrow by mentioning above information for onward submission to the AMSCL authority for taking necessary decision on your plea.
So decision
Now,
was that we
Mr.
will go for
Gogoi,
so cause.
where is this decision?
Yes, it will be there in the office note, my lord.
Where
Just
is the
deliver it.
decision? Please show me the decision.
My lord, these cannot, my lord, no right
I
accrues, my
want
lord.
the decision, Mr. Gogoi.
My lord, my lord.
You may have a valid reason. Right now, I'm on the decision-making process.
The decision-making process.
You yourself have said that you give me this for an onward submission discussion. They gave it immediately.
Lordship.
Now, what did you do?
Yes, it's there, my lord. I've got the e-file of this particular.
Are you carrying any authorities on blacklisting?
Yes, my lord.
Yes.
I also have, my lord.
Yes.
Of that,
Because I think both lines are there.
Yes.
Some decisions for you, some against you.
No, my lord, I am submitting, my lord, that first thing, the contents of the notice, that is very clearly written by Supreme Court, my lord. That
And
what
we-
should be there.
We will see.
I have it, my lord.
Huh?
Local duty, that department, you have divided on.
Oh, I'm sorry. I'm holding it here, man. Yes.
You take your time, no problem.
No, I've got it.
Because the whole purpose of keeping it today was to see this decision.
Lordship.
Yes.
Yes, sir.
Which the first flag.
Plus, yes, Lordship will see, my lord, 5/2/2025.
Yes.
Then Lordship will see 16/2025, 17/25, there says, my lord, please refer to the note above. To ensure the availability of the drug, we will extend the delivery period by an additional 7 days. So while putting up the files, my lord, by the lower authorities, not the, my lord, the MD, they suggested that instead of 15 days, at least we may go for 7 days. They have suggested. Then this continued. It is the general manager, my lord. Now, lordship may turn to the next page.
Yes.
Then in the meantime, my lord, yes, the lordship may have a look at this now, my lord. Due to the, my lord, technical glitch, my lord, they have some problem. Then from 16 to 17 to, my lord, this is the, my lord, office note.
Huh?
They decided that we'll go for, my lord, we will issue show cause. No point of extending, though, my lord, there was suggestion was made for 7 days. Lordship will see, Agron so-and-so was awarded so-and-so. Several reminders were sent to your company over phone as well as so-and-so. All this, my lord, chart is there, my lord, 17 to 2025. Now the office note starts at, my lord, in the next page.
This has been, this is in your file.
Yes, it is there, my lord. My lord, on 17 to there are some technical glitch, my lord.
But
So
has
the
this
issue
been
file could not be.
communicated to them, this rejection?
No. Communication, my lord, how, why are we required to, my lord, communicate
Why?
to the petitioner?
Why?
No, my lord, they have submitted several extensions,
They
my lord.
have sought for an extension.
Yes.
You want to.
The moment we have issued the
You are
so-called.
considered, Mr. Gogoi, you are a state here. That is the basic requirement of you. You may have your right to
Cannot be,
reject
my lord.
it.
No, it cannot be. My lord, Lord
I'm
Civil
not
still.
impressed. I'm sorry, Mr. Gogoi. This cannot be.
No,
like
no, no,
this.
Lord Civil kindly see
You
that
may-
for a moment the conduct of the petitioner, Lord Civil. After all,
comes
my lord,
later.
my lord, these are life-saving medicines, my lord.
Mr. Gogoi,
The
then
time is
why-
75
Mr.
days.
Gogoi, then why did you ask them for giving this detail?
No, my lord,
And you said
no, in a
for
disoriented
taking
manner, my lord.
necessary decisions.
In a disoriented manner, they have submitted a representation. We sought for it, that just give me the supply orders as well as the medicine, as well as the date of the supply order. At least we can verify in the record. On verification, what we have found is in the so-called. Lordship may kindly have a look at the dates, my lord.
Which date?
Just for a moment, page 99. Just for a moment, Lordship will see the conduct of the petitioner. These are life-saving medicines, my lord. We cannot wait for them, my lord, for 2-3 months. Page 99. Lordship will see, my lord, serial number 4. The conduct of the petitioner has seriously affected the supply chain, my lord. That is what has been informed by the authorities. From 2022, my lord, we will file an affidavit, my lord, we bring to record everything. The Lord
Yes,
Civil see page 99 for a moment. Just I want to place certain, my lord, figures.
Yes.
Serial number 4 is the, my lord, supply order which finds place in their communication at 10-2. Serial number 4.
Yes.
It says, my lord, Lordship, it is the period they should have supplied by 6/12/2000.
Number
Serial number 4.
4 you have demonstrated.
Yes, 5 Lordship will see. Total, my lord, days passed since approval 147, same. 0 supply. Not a single supply has been made. They are supposed to supply within, my lord, 75 days. But after all, my lord, is the rural, my lord, poor people who are suffering, my lord.
My lord, this is perverse.
Entire supply chain, my lord, has got, my lord, disoriented because of this particular conduct of the petitioner.
My lord,
He is
this-
the L1 bidder. These are medicines which he will have to supply. As a result of which we will have to procure, we had to procure it from the L2 bidder, L3 bidder after negotiation. Because, my lord, it is the patients who will suffer, my lord. They are being provided
Right now,
with these
here
medicines.
they are challenging which one? The fresh procurement or only the blacklisting?
No, only the blacklisting. That also, my lord.
My lord, your lordship,
Interim order, let me complete. Interim order, my lord, against them, my lord, final, it will amount to issuing a final order. Is a debarment notice, if that is stayed, what remains, my lord?
Are you carrying those authority where I think that
Yes, yes.
just give
My lord, regarding blacklisting part, of course, my lord, that Gurkha security is very clear. Their contention is there.
because I remember there are 2 lines of perception.
Yes.
Which one will be against you, one will be for you.
No, my lord, the issue is, Honorable Court, Supreme Court is very clear in this regard that we will have to give an opportunity to the petitioner before, my lord, taking such a,
Blacklisting.
yes. That I will have to demonstrate.
So here, whether that was done.
It was done, my lord. In fact, my lord, I would say.
Because what is shown here is the final order.
Yes.
This order of 105.
Yes, ma'am.
Any show cause was given before that?
Yes, so cause for blacklisting has not been given.
The Lordship will
That
say
is,
page,
some department has been given, and moreover, my lord, one thing I must make it clear that they have shown 0, but 100% they have supplied. That is,
All right, Mr. Sawala,
that is
let
wrongly
me
they have
just,
shown.
let me hear the
Yes.
state one.
That is perverse.
You
Page-
have a right.
page 97 is the so cause, my lord. It will,
97.
yes. May I place the so cause first, my lord, then I will place the
Yes, yes.
citation. my lord. Lordship will see, petitioner has referred to, my lord, the first line in the last para.
Yes, but here I
It
recollect.
says, my lord, yes, your product
Debarred. Product should
should
not
not be debarred. Now, may I continue further? May I continue further? my lord?
Yes.
Hence, in the greater public interest, you are asked to show cause why your product should not be debarred as per the referral panel clause of the tender, that is clause number 5, terms and conditions, subclause H, debarment, blacklisting for failure in execution of supply, non-supply, default in supply. Point number 1, Lordship will see product debarment.
Where are you reading from?
My lord, in the page 97, the last para, hence.
Yes, yes, yes.
Hence, in the greater public interest, you are asked to show cause why your product should not be debarred as per the referral panel clauses of the tender, that is clause number 5, terms and conditions. Subclause H, debarment, blacklisting for failure in execution of supply, non-supply, default in supplying. Point number 1, product debarment, where it was mentioned that in case of non-supply or incomplete supply, that is less than 90% of the total ordered quantity by the approved manufacturer, importer, firm, within agreed delivery period, including the delay, penalty period, or any such extended delivery period, then the concerned contract shall be cancelled and the manufacturer, importer shall be debarred. Lordship will see the manufacturer, this is the clause, my lord, shall be debarred for participating in any bid called by the authority for 5 years from the date of debarment of that item. In case the manufacturer or importer supplies 90% or more of the ordered quantity, but fails to supply the entire quantity within the allowed delivery period, then the firm shall be levied a penalty of 10% of the value of the short supplied item, and same shall be adjusted against the payment for supply. Now, point number 2, we have mentioned it. Firm debarment. It is there in the show cause. The item shall be blacklisted. This is very important, my lord. Page 98, Lordship may see. Point number 2, firm debarment. The firm shall be blacklisted and debarred from participating in any tender by the TIA, that is tender inviting authority, or procuring agency.
This is what you have quoted from there, no?
Yes, it is mentioned. May I read further? Why, my lord? Automatically, it will be blacklisted. The firm will be blacklisted. That Lordship will find in page 98.
No, because see, only problem is that it is not clear because the subsequent things are the is what the clause 5 says. This what you're reading is part of clause number 5, right?
Yes, yes, part of
Subclause H.
Yes.
This is, it starts with the quote,
Yes,
correct?
yes, ma'am.
So that quote goes on. Until down,
Now, point number 2, my lord, otherwise, my lord, by the so cause we are supposed to inform the petitioner about our intention.
correct. Now that
So,
intention,
firm debarment,
if
Lordship,
you
my lord,
come-
why I am saying it.
you
will be auto-
finally, when you come down, you are also hereby asked, oh, you have said.
Also, and my lord, why, my lord, automatically it will be debarred. May I, my lord, read that part, my lord? Only one part. my lord.
Okay, you have made your point.
Yes,
All
firm
right, Mr.
debarment.
Gupta, I have understood.
But just, my lord, it will be more
I've
clear.
understood, you have made your point.
Because, my lord, 3 items, if it is debarred, automatically the.
Understood.
Yes.
I'm with you.
And, my lord, the petitioner is defaulted for 19.
First, you said, hence in the greater interest, you are asked show cause why your product should not be debarred.
Yes.
As per the referred panel clause of tender, so and so, terms and conditions, debarment, blacklisting, and so and so.
My lord.
Then in the last paragraph, you said you are also hereby asked why your product should not be debarred as per so and so. So that means according to you, you have been given the sufficient cost to show
At least,
as
my lord,
why
from
the
the, yes,
penalty
sense of the so cause notice, it is very
clause
clear.
H should not be
My lord, the
imposed.
The
Yes.
law in this regard as on that stands that my lordship may have a look at 2014 9 SCC 105.
This is 2003.
2014 9 SCC 105. Now, Lordship may have a directly have a look at para 20. Para 20. It's directly on blacklisting and debarment. Thus, there is no dispute about the requirement of serving show cause notice. We may also hasten to add that once show cause notice is given, an opportunity to reply to the show cause notice afforded, it is not even necessary to give an oral hearing. Lordship will mark this, my lord. The High Court has rightly repudiated the appellant's attempt in finding foul in the impugn order on this ground. Such a contention was specially repealed in Petrol engineering. Now, 21. The central issue, however, pertains to the requirement of stating the action which is proposed to be taken. The fundamental purpose behind the serving of show cause notice is to make the noticee understand the precise case set up against him which he has to meet. This would require the statement of imputations detailing out the alleged breaches and defaults he had committed, so that he gets an opportunity to rebut the same. Another requirement, according to us, is the nature of action which is proposed to be taken for such a breach. That should also be stated so that the noticee is able to point out that proposed action is not warranted in the given case, even if the default or breaches complained of are not satisfactorily explained. When it comes to blacklisting, this requirement becomes all the more imperative, having regard to the fact that it is Hersey's possible action. 22 is again important, my lord. The High Court has simply stated the purpose of show cause notice is primarily to enable the noticee to meet the grounds on which the action is proposed against him. No doubt the Honorable Court is justified to this extent. However, it is equally important to mention as to what would be the consequence if the noticee does not satisfactorily meet the grounds on which an action is proposed. To put in otherwise, we are of the opinion that in order to fulfill the requirement of principle of natural justice, a show cause notice should meet the following two requirements. The material grounds to be stated which according to the department necessitates an action. 2. Particular penalty action which is proposed to be taken. It is this second requirement which the High Court has failed to omit. Now, last line is again important, my lord. We may hasten to add that even if it is not specifically mentioned in the show cause notice, but it can clearly and safely be discerned from the reading thereof that would be sufficient to meet the requirement. That penal provision we have mentioned, my lord, that the firm will be debarred. This goes to the root of the issue, my lord. This directly, my lord, it saves us. Otherwise, my lord, at least at this interim stage.
Okay.
And my lord, regarding my lord, the prayer for staying of the debarment notice, my lord, I have got two citations to place that, my lord,
Which is
interim orders cannot be final orders.
2003-4.
Yes, my lord, 3-4.
Para
My lord, 2000, 2010, volume 11. Those are pertaining to, my lord, termination from service or dismissal from service, but my lord, it has been explained why such orders should not be directly state.
I think 10 is not here.
Volume 2000. Yes. 2010, 311. 2010, volume 10, 311. Very short, my lord, only one para. This appeal by the state of Haryana is directed against an interim order passed by the Honorable Court of Punjab and Haryana at Chandigarh in CWC so and so, staying the order of termination. The positive case of the state is that the respondent did not pass the necessary examination in the shorthand and typing. We are not expressing any opinion as to whether the services of an employee should be terminated for not passing the shorthand or typing test, but we are clearly of the opinion the High Court erred in law in staying the order of termination as an interim measure in the pending writ petition. By such interim order, if an employee is allowed to continue in service and then ultimately the writ petition is dismissed, then it would tantamount to usurpation of the public office without any right to the same. We therefore set aside the impugn order.
Relevant.
No, why I'm saying is the impact, my lord. Moment the debarment is, my lord, stayed by this Honorable Court. We have no faith in the petitioner. My lordship will see every time, my lord, I have got, my lord, these are lordship may kindly have a look at this.
I think that is not required.
Yes, otherwise, my lord, by the law, my lord, I think I
Is
have.
that interim final order, that decision?
My 2003-4 FCC, same, my lord, on the same issue regarding suspension if it is interfered with.
No, there are categorical decisions of the appellate court, right?
Yes,
But,
sir.
You cannot grant the interim order if granting interim order will amount to
Amount to-
final
yes.
disposal of. the-
Here is a case, my lord, moment debarment is stayed, we will have to, my lord, again issue supply orders or accept, my lord, supplies from it. We assume that there is no trust on the my lord, employer on the present petitioner.
Okay.
Lordship will
Yes,
definitely
Mr. Sahay-
adjudicate us. Lordship will give us short time, we will file a affidavit.
Mr. Sahaiwala?
My lord, and my lord, your lordship will see what the so-called notice. First thing, my lord, they have not given anything, my lord, regarding extension. One thing, my lord, because they want the medicines. Our medicines were, my lord, reached, my lord, virtually Guwahati almost at the time we prayed for 15 days time. Secondly, my lord, what my learned friend is submitting, that the so-called notice, my lord, has been issued without replying. It is first, my lord, the page 97, my learned friend says, that is, they have quoted the, my lord, should not be debarred, my lord, as per penal clause. This is also debarred, my lord, penal clause. But ultimately, what they have said, my lord, the penultimate paragraph says, my lord, why the product should not be debarred. My lord, this my learned friend,
debarred.
my learned friend had relied on Gorkha security. Gorkha security is very clear, my lord, that what for what purpose you have issued the notice, my lord. And secondly, my lord, my learned friend has said that some medicines with zero supply. My lord, this is perverse, my lord. If your losses may see my subsequent, my lord, petition at page 110.
Yes.
My lord, last sentence, your lordship may see. Additionally, we have observed the discrepancy between attached supply details in your letter and data recorded so-and-so portal. Contrary to information on your letter, we have fully supplied certain products, but they are as per so-and-so receiving warehouse signed, and we have supplied item number 6 and 7, 100% folic acid at acid to designated station, 100% glyphosate 1 tablet, my lord. They are incorrectly shown as 0%. Well, they have shown it 0%. We have supplied 100%, my lord. My learned friend shown, my lord, that 0% we have supplied. That is 100% we have supplied, my lord. This is perverse, my lord. That is what. They have not considered it, my lord. Then other items are also there, my lord. So how 100% we have supplied, my lord, and they shown it 0%?
All right.
My lord, so my humble submission, first thing, my lord, they wanted to consider my application for extension. That was nothing has been done. Secondly, my lord, this any way, my lord, this so-called notice will be regarding quotation of the, my lord, the clauses will not do, my lord. They have quoted the clause, my lord. I have already placed, my lord, the clause at page 44.
Let's read para 97 again.
Yes, my lord.
Page 97,
My-
because at
Correct.
the end of the day, the test is to see whether 97 fulfilled Gorkha.
My lord.
Correct.
Yes.
Let's
Hence
read
in
slowly.
hence in greater interest, public interest, you are hereby asked to show cause why your products should not be debarred as per the referral penal clauses of the tender. Clause number so and so. So your products should not be debarred.
Let's read.
Yes.
Mr. Saiwala, just
Yes.
read.
Then, my lord, they have quoted the clause only.
Read, read.
Yes. Clause 5, tender subclause A is debarment, blacklisting for failure extension to supply so and so. Product debarment. Where it was mentioned that in case
Point
of,
number 1.
my lord, yes,
See, the court is closed.
yes.
Then it says point number 1. Read.
Where it was mentioned that in case of non-supply of or incomplete supply, less than 90% of the total ordered quantity by the approved manufacturer's importer within the agreed delivery period, including the delay penalty period or any other extended delivery period, then the concerned contract shall be cancelled and the manufacturer importer shall be debarred from participating in any bid called by the authority for 5 years from the date of debarment for that item. In case manufacturer importer supply 90% or more ordered quantity and fails to supply the entire quantity within the allowed delivery period, then the firm shall be levied a penalty of 10% of value of the source supplied item and same shall be adjusted against the payment of supply of so and so. Then point number 2, well, this is, well, that they have not so cause for this. The firm shall be blacklisted and debarred from participating in a tender by TIA or producing agency for 3 years if the company is debarred for all items, at least 3 items so and so, as per my lord clause 1. So first thing, my lord, they have to debar me from the farm, the product debarment.
Where do I get that clause H?
My lord, page 44, my lord, your losses may see, my lord. That will be bigger side, my lord. Page 44. From the LY.
Yes.
This is product debarment, my lord. Then farm debarment. If the company is debarred from all items, my lord, if you also see farm debarment, the farm shall be blacklisted and debarred from participation in tender or TIA procuring agency for 3 years. If the company is debarred from all items, where I have debarred? I have not been debarred. That SOCO notice is given for this. Wherein RC data contract is less than 40 years or at least 3 items. So and so and so. So first, my lord, the product debarment order is to be issued. If product debarment order is issued, then only I can be blacklisted. Not, my lord, prior to that.
All right.
But
My
this
lord.
is
And
cannot.
secondly, my lord, secondly, I have already said, my lord, the LOI has been issued. All the orders has been issued by the managing director.
Okay. Take down.
And moreover, my lord, I am submitting some decisions, my lord, of the Supreme Court. My lord, I'm just. And
On blacklisting.
I'm
On blacklisting.
on blacklisting, exceptionally on blacklisting. My lord, our court the judgment is also there, my lord. There is another judgment I could not find out of High Court, my lord. First is 1989 1 SCC. My lord. Raghunath Thakur.
Yes.
That's the loss messy.
Paragraph.
Paragraph, my lord, 4. Indisputably, no notice has been given to the appellant of the proposal of blacklisting of appellant, which was contended on behalf of the state government that there was no requirement, the rule for giving prior notice before blacklisting any person. In so far the contention, there is no requirement.
All right, this is without notice.
Yes, no, then hearing, my lord. Notice concerned is respondent right, but it is implied principle of rule of law that any order having civil consequences should be passed only after following the principle of natural justice. It has been realized that blacklisting any person in respect of business venture has civil consequences for the future business of the person concerned in any event. Even if the rule does not express so, it is elementary principle of natural justice that parties affected by any order should have right of being heard and making representation against the order. Two things, my lord. So making representation and being heard.
Okay.
Then this was followed by, my lord, the second case, my lord. If you also see, my lord.
Daffodils for pharmaceuticals.
Daffodil also, my lord, if you also see 20, page 18.
Para?
14.
Notice.
No, 14 is quoted, my lord, here. I 59 coming.
Notice.
Yes. That
Notice.
My lord?
Notice before blacklisting.
Yes, on blacklisting.
Okay. Then
2020 18 SCG, para 14, my lord, that has been quoted. Then if you'll also see, my lord, para 15. Para 15.
all right. This is 2020. I have noted. Then 2023.
Yes, my lord.
Para?
23, my lord.
The same point. So no one authority is good enough.
My lord, yes.
Yes.
23, my lord, that your losses may see 98.4. Earlier discussions are there. 98.4 at page 47.
4.
Yes. Such debarment clause under so and so. My lord, there was another case, that is why I said master of frauds is akin to blacklisting of the borrowers from being unworthy and unworthy. Court consider that an opportunity of being hearing ought to be provided before a person is blacklisted. Other discussions are there, my lord, paragraph 13 to 18.
Yes.
And then our High Court order is there.
Yes.
Counter to this, my lord.
Wait, he's not. Why are you getting patient, Mr. Gogoi?
This is, my lord, National Health Mission. Same, my lord, virtually. Para 17. Without entering into controversy.
Yes, our High Court.
Our High Court, my lord. That Omega Biotech, it is also supply of drugs, my lord.
Para
17. Without entering into controversy on merits and consequently without commenting on the same, The court was viewed as debarment notice is nothing but blacklisting or petitioner. There is hardly any difference between blacklisting and debarment. How an order of blacklisting or debarment is drastic step enabling adverse civil consequences upon the contractor or supplier in question. A declaration or recording a finding that the drug supplied to petitioner is not of standard quality is one thing, and taking decision to blacklist or debar the supplier for a limited duration for the future is altogether another thing.
That page is missing.
My lord? Oh, I'm sorry, my lord.
That page is missing.
I'm sorry, my lord. Some looking there, my lord.
You read it and then you give it.
Yes, madam. My lord. My lord, uh, taking this one up to blacklist and debar the supplier for limited duration in future is altogether another thing. Since the order of debarment entails adverse civil consequences, it is essential that reasonable adequate opportunity of hearing is afforded to the contractor or supplier concerned before passing an order of debarment. From the impending debarment notice that is so and so, it is discernible that such opportunity of hearing was afforded to petitioner. That apart, with regard to the consequence of debarment, it is important that debarment notice or order should be a speaking order. Must merely saying that petitioner failed to furnish satisfactory reply should not be sufficient to pass. Here, my lord, my so-called reply has been not considered at all. If you will also see, not a single sentence has been considered. My reply, not a single sentence.
Okay, Borua, এখানে last page টা হয়ে গেল। Last page to লৈ লওক। Just give the last page.
Yes, ma'am.
Because only one page was left, na? Really?
Hello, so-called reply is meant for consideration. They have not.
All right, Mr. Sahewala,
Hello.
we are not taking up
Hello.
for final hearing today.
Yes.
Yes, Mr. Gogoi, what?
Well, so far as their contention that they ought to have been heard. The judgment says only hearing. Doesn't mean that
Okay,
no SOCOS is required to be issued.
Or
Hearing doesn't mean that it will have to be a personal hearing, 1996, there is a specific judgment. The word hearing, it's not like a court, that he will have to be personally heard.
All
Giving the SOCOS is enough.
all right. Looks like you want me to finally decide the matter.
I will file our affidavit in a short time,
Heard Mr. G.N. Sahewala, Learned Senior Counsel, assisted by Mr. M. Sahewala, Learned Counsel, appearing for the petitioner. Stop. Also heard Mr. B. Gogoi, Learned Additional Advocate General for the State Stroke Standing Council, held. Correct? Also Standing Council held. Or not
Yes,
necessarily?
your may reported, because NSM and held, I am already a standing counsel. But one more thing, just since petitioner has said that where we have referred as zero supply.
Mr. Gogoi, I'm not going into all that.
Yes, because
I'm not going into all that right now. I'm not
only on the legal
married.
point.
You see, the problem is that when you know the court is giving an order, I don't know why you all get so anxious.
I
For consideration of interim prayer, need not go into all these details.
I'm obliged.
Otherwise, your final hearing gets
Yes.
affected.
Obliged.
If today this court makes observation into all this, one of you is bound to get affected. Why are you inviting me to give you a finding on all that? এবোৰ কি কৰি আছে অথনিৰ পৰা কি কৰি আছে কৈ দিয়ক ৰেজিষ্ট্ৰাৰক এইটো আফটাৰ কোৰ্ট আৱাৰ্ছ কৰিব লাগে This is not the way of doing all this. It is obstructing the administration of justice work. Court time of set kora. Call up the registry. কি লিখিলা মাৰি দিয়ক এডমিনিষ্ট্ৰেশ্যনৰ কাবাক ৰেজিষ্ট্ৰি মান মাৰি দিয়ক In terms of the order dated 16/5/2025, this matter was taken up today for consideration of the interim was taken up for consideration of the interim relief. Stop. The facts of the case was that the petitioner company being blacklisted by the impugned order dated 10/3/2025 for non-supply of what products?
Medicines.
Where do I get the reference? Just give me a page where I get the reference.
Page 105, my lord, that's the time you got it.
105
Yes. In the order.
for non-supply of
Essential medicines.
essential medicines. In order to date to deliver for non-supply of the essential medicines, comma, the writ petition, the instant writ petition has been filed seeking the following prayer, quote unquote, page 32, A to A. Okay. Mr. So-and-so, learned senior counsel, learned senior counsel appearing for the petitioner submits that the debarment, that the impugned blacklisting has not been preceded by issuance of any opportunity, by issuance of any show cause notice and or opportunity of hearing to the petitioner. And therefore, the impugned decision of blacklisting is totally illegal and void ab initio. In support of the aforesaid submission, he relies upon the following decisions of the following decisions. Number 1, 1989, volume 1, volume 2, 1 SSC 229, party number didiba ami janeke likhum ha. Number 1 hetu. Number 2, 2020 18 Supreme Court cases 550. Number 3, 2023 6 Supreme Court cases 1. And the decision of the coordinate bench of this court in the case of Omega Biotech Limited versus State of Assam and others in WPC 1056 of 2018. Per contra, Mr. Gogoi, learned so-and-so, submits that prior to issuance of the impugned blacklisting order, the petitioner has been given show cause notice wide letter dated 17/2/2025 to show cause as to why the penal consequences in terms of clause H, in terms of subclause H of clause number 5 of the terms, this is of the contract, no? Of the terms and
Yes,
condition of the
terms and
contract.
condition. But the one that has been referred by the petitioner in the writ petition, that is not the contract, my lord. I've got that particular.
But what
clause.
is this clause?
Clause M and H is here. This is the contract.
It's a part of the contract, right?
It's part of the contract. Yes, it's
No,
part of
I'm referring to your thing now.
Yes, it is part of the contract.
You give me wherever it is.
Right.
Subclause, I'm only referring to your letter now,
Yes, sir.
not to the clause which the petitioner is referring.
Yes.
This reference is there at page 97.
Yes.
Subclause H of clause number 5 of the terms and condition of the tender. Correct?
Right.
Of the subject tender.
Yes.
It took sentence to complete whole. Na? Stop. He accordingly submits that he further submits that because the petitioner could not supply the essential medicines, which is essential medicines as per the stipulated and further extended time in respect of few items, no further extension as granted, as sought for by the petitioner was granted, and because of such failure and default, the action of blacklisting, debarment had to be taken against the petitioner in the larger public interest. In support of the, he further submits that if the debarment stroke blacklisting is stayed, it shall have serious prejudice to the interest of the to larger public interest, as because of the non-supply of the essential medicines in the hospitals, there were short, what were you saying? There were short,
Yes, short.
there were shortage of the essential medicines. Stop. In support of the aforesaid submission, he relies upon the decision of the Apex Court in 2014, 9 SSC 105, Arueta, 2003, 4 SSC 104. I have heard the submissions advanced by the learned senior counsel appearing for the petitioner, as well as the learned additional advocate general appearing for the state respondent, and have perused the material and have perused the materials available on record. I have also duly considered the citations, case law cited at the bar. Undoubtedly, blacklisting has drastic consequences, and therefore it is utmost essential that before such harsh and drastic step is taken, due opportunity is provided to the contractor. In the present case, it appears that before issuing the impugned blacklisting order, a show cause notice dated 17/2/2025 was issued to the writ petitioner to show cause notice for default in supply of items placed at annexure A of the said show cause notice. Apt to reproduce the aforesaid show cause notice for ready reference, quote unquote, page 97, A to A. Where do I get the entire clause? Tender clause.
Lordship will find internal page 22. At the bottom, page 22.
Yes.
At the top, H. And 25 is M, specifically. H. And page 25 is clause number M. So these are two clauses that has been referred.
Page 20.
5. In the middle, alternative purchase M, this was referred.
Now this H is part of what?
It's the, my lordship will see the first page. Framework agreement with manufacturers for supply of essential drugs.
No, it starts from where? A,
Yes,
I think
my lord.
terms
Yes,
and condition 5. It starts
starts,
from
my lord,
clause
5.
5.
This is terms and conditions.
Right.
Yes, madam.
Reading of the aforesaid notice, it appears that since the petitioner company could not complete the required supply within the contractual delivery period and period with highest late delivery charges has also crossed at the rate 2% of the value of delayed goods per week of delay or part thereof, subject to a maximum of 10% of the total order value. The in the greater public interest, the petitioner company was asked to show cause as to why the product of the petitioner should not be debarred as per the referred panel clauses of the tender, I clause number 5, within quotes terms and condition, subclause H, within quotes debarment stroke blacklisting. It appears that under clause 5 of the tender, subject tender, subclause H provides for debarment stroke blacklisting for failure in execution of supply stroke non-supply stroke default in supply. At this stage, let's stop Cora. Apt to refer to the case of the decision of the apex court in the case of Gorkha Security Services Supra, wherein the apex court has held as under those paragraph you referred 20, na? Quote unquote para 20, 21 and 22.
20, 21 and 22.
quote unquote. Reading of the aforesaid paragraphs, it is clear that it is imperative for the authorities to intimate the contractor as regards the proposed action of debarment stroke blacklisting before issuing such harshest possible action. It is further clear that the apex court has emphasized that to fulfill the requirements of principles of natural justice, a show cause notice should meet the following two requirements. Number one, the material stroke grounds to be stated which according to the department necessitates an action. Number two, particular penalty stroke action which is proposed to be taken. It is this second requirement which full stop. Without entering into the controversy on merits and consequently without commenting on the same, this court is of the view that the show cause notice issued to the petitioner prima facie contains the material grounds necessitating the impugned blacklisting order as well as the proposed penalty stroke action. That being so, okay, that being so, this is not a fit case for staying the staying the order of the blacklisting, impugned blacklisting as sought for. Mr. Gogoi has assured that the affidavit in opposition shall be filed within a short period. Yes, how much?
My lord, within 2 weeks, my lord. By 13, we will file it.
Let the affidavit in opposition be filed by
13th of June.
within to be within record, yeah. Within 13?
Well,
13 what?
13th of June.
Oh, 13 June.
Yeah, we can. file it.
Then you give it in his Mr. B. Gogoi, Learned Additional Advocate General of the for the state assures that the affidavit that the return in the writ petition shall be submitted by latest by 13/6/2025.
Right.
You want to file your reply by
1 week.
2 weeks. 2 weeks.
then I'm not saying. Otherwise, I would have put the calendar.
1 week, 1 week.
Are you sure?
Yes.
Mr. Jain Sahewalla, Learned Senior Counsel, also submits that after receipt of the return, the rejoinder against such return shall be submitted within 1 week. 1 week from within 1 week. Stop. Yes. When should I list it?
24th, my lord. 24th of June. There is a Tuesday.
In view of the list for admission on
24th June.
24/6/2025. It is needless. I think if I make that, it would be imposing
No, lordship.
the whoever the bench takes to take up the hearing for final disposal, because if the
No, we-
pleadings are complete, you both can make that prayer, because it is in your interest that
My lord.
the matter is heard and the
Yes.
blacklisting goes.
My lord.
I may edit the order a little. Perhaps that public
Well.
interest angle, I might just,
Lord.
in my reasons
Well.
for not giving the interim, I'm going to add
My
that.
lord.
You will get it by the.
Highly obliged.
Have you given anything here? Any papers?
Original document has been furnished, by. These are all photocopies.
For hearing, item number 5.
May I please, your lordship?
Yes.
Lordship, may kindly see the order dated 29/11/2024.
Hmm?
29/11/2024.
Completed, lordship. Both sides, we completed the hearing, lordship.
Completed.
Lordship.
Yes, my lord. And we have already filed our written argument also, my lord.
I have forgotten, Mr. Gogoi.
Lordship. Then, lordship, any,
Huh?
we are not filing written argument. Otherwise, as per my lord's direction, we have filed a compilation of the judgment, lordship.
That is done.
That is done, lordship.
What was the issue?
Issue was that, lordship, there was a conditional appointment, lordship.
There was a
Conditional appointment, lordship, the lecturer. lordship.
conditional appointment.
Conditional appointment, he should clear net and slate, lordship, within a specified period of time, lordship. That is there, lordship. Now he is seeking that benefit from the period where he has not obtained the net and slate, lordship.
He is seeking the benefit from
From the date of appointment. lordship. Initial appointment. Otherwise, law is well settled by our High Court. Several judgment I have given, lordship. It says that from the date of lordship acquiring the lordship net and slate, lordship, or PSD.
this is the UGC regulation. Who has given?
Lordship, I have given.
Who has given?
Here judgment also there, lordship. Since 1991 itself, lordship, the UGC's regulation.
Just 1 second.
Lordship. That compilation includes the judgment also, lordship.
What is this? Why is this document like this? This Kalyani Mathivanan is by you.
Lordship, I have given, I did.
These two judgments you are relying.
Lordship, I have their compilation part, I have compilation. All judgments are there, lordship.
Here only.
Lordship, all compilations are there. All the judgment, lordship.
Oh, your argument is also here.
We have not given a written argument, otherwise as per my lord's direction, we have submitted that lordship, the judgment which was, I am relying lordship.
This judgment of Justice Surana.
Surana's, my lord justice, Surana's judgment is also there lordship, and other judgment also there lordship. My lord justice, UKNI judgment is there, and my lord justice, HK Roy judgment is also there lordship.
This Jyoti Rupa, there is a appeal pending.
Appeal pending Jyoti Rupa lordship.
Where?
In
division bench.
division bench. Otherwise, lordship, the judgment which was delivered by my lord justice lordship, H Roy lordship, it was attained finality lordship.
Those are here.
Yes, lordship, yes.
You have not given any index, Mr. Gogoi.
Lordship.
Why? Give an index.
Lordship, lordship. Then lordship,
It will be easier for this court
Lordship.
to.
lordship.
And what is, who have given all this?
Only listening.
My lord, yes, my lord.
Huh? You have.
2015-6 SCC, my lord.
Huh?
We have filed written argument, my lord, along with written argument.
You have
we
given a written argument.
filed
Where is your written argument?
on 12/12/2024, my lord.
Yes.
In the written argument, we have, my lord, referred this judgments, my lord. 4 judgments we have relied,
4, right?
my lord. And the first judgment is the, my lord,
1 second.
2015-6 SCC.
Four decisions.
My lord.
You just give me that index.
Lordship, lordship.
When?
Maybe I will supply next week.
You don't have to, you just have to just,
Lordship.
you can,
One thing also, lordship has put query to us, lordship. Although I have, lordship, replied that part for lordship, page 47 of the writ petition also.
Page?
Page 47 of the writ petition.
Yes.
Lordship has directed us to place the same lordship.
Page 47.
47 lordship. It's a minutes of the meeting of the lordship. 47. No, no, 47 is the minutes of the lordship meeting held in the lordship office chamber of the Minister of Education lordship.
Yeah.
And it was never implemented lordship.
It was never?
Never implemented lordship.
Not implemented.
Not implemented, even not notified. We cannot lordship overreach that particular, we cannot violate the lordship, the statutory prescription prescribed by the statute lordship. There was a meeting between the stakeholders lordship. That meeting lordship cannot.
Mr. Gogoi, you just prepare the index.
Lordship.
And
If required, I can file also written argument also. If lordship.
give a written argument.
Then
That would be
lordship next week, my lord, I will next.
Tuesday?
Thursday lordship.
Next Thursday.
lordship.
Mr.
Next
K.
Thursday.
Gogoi, learned counsel appearing for
Higher education.
higher education.
Last question I can say.
1 week time to file written argument in the matter. Petitioner has already filed the written argument. Relist on Thursday, so and so date for further hearing.
May give the compilation, I can index also, I can.
You give your written argument.
Along with the index, along with the.
You return that compilation to me. Please take it. Thursday.
Thursday.
Those are part third.
Yes, ma'am. This case, your lordship, we have submitted the written the notes, my lord. Earlier occasion, we have submitted the written notes. Your lordship has taken written notes of parties, my lord. All the parties.
Written what?
Written notes of the all the parties.
Kaliji stated this thing. Kaliji to this What was the issue?
Issue was, my lord, there is an advertisement to fill up a post of, my lord, assistant engineer in the Karbi Anglong, my lord. So there is an advertisement, man, for the only one for one post, and the qualification is, my lord, BE. BE, my lord. Thereafter, my lord, the respondent authority, my lord, after conducting appointed 2 persons, my lord. The first, my lord, respondent number 4, he is not qualified, my lord, because he is not BE. There is no in the advertisement that equivalent to BE. There is no such kind of assertion, my lord. So secondly, my lord, there is only for one post, the person has been appointed, my lord, 2 persons. That is the issue, my lord.
Mr. Kayal was
Oh, my lord.
appearing for
Yes, may I ask to whether that institute is a recognized institute or not, my lord.
that instruction was given.
They have already filed, my lord,
affidavit clear, my lord, whether that institute, my lord,
Yes, because
Institute of Civil Engineers, Ludhiana, Punjab is a recognized institute or not, my lord.
I think that is what was required.
My lord, my lord.
Where is Mr. Kayal? Where is your affidavit?
Respondent. Respondent number 7 affidavit.
Respondent number
7.
I think maybe page 80. Chronologically.
Page
80 possibly.
9.
7 in it.
Yes. the details of the institutions, professional bodies, including Institution of Civil Engineers, Ludhiana, having permanent recognition are also available in so and so. Now, this institute is mentioned here.
My lord. My lord, here, my lord, in the serial number 4, my lord, where they have provided, not clearly stated, my lord. The Institute of Civil serial number 4, where the in the bottom of the my lord, that notification memorandum, serial number 4, Institute of Civil Engineers, Ludhiana, bracket PB, my lord. Whether this is, my lord, communications is amounts to, my lord, continuation, because, my lord, initially the institute recognized.
Where page?
Page 86, my lord. The annexure 1 of that, my lord, affidavit filed by the respondent number 7, my lord.
Page 86 is annexure 3.
My lord, 83. Okay, maybe 83, my lord.
Yes.
So they are relying
In
this.
case the institute, yes, which one? Page 83 I have, yes.
My this is the, my lord, modification of the earlier order so, my lord, they facilitate the institution during the transitional period. Following decision has been taken in the ministry. These are the, my lord, guideline that where, my lord, up to 31st/5/2013, my lord, we have the permanent recognition, they are eligible for, my lord, whatever it is, my lord. So here, my lord, they have not mentioned that this institute is, my lord, recognized institute. This is a general notification till 2013.
A lot of time has gone by since
Yes.
I had last
My lord.
heard this matter
My lord,
because
process supposed to pass in.
More than 1 month suffice.
yes, that's
Order was
why
approved, my lord.
I think we
My
will
lord,
have
my lord.
to we'll
I
have to
have-
look
my
into
lord,
it a little.
With not change judgment,
deeper.
I have cited, my lord,
Yes.
already, my lord, submitted. My lord.
The all of both side has given your.
My lord, my lord, my lord.
This is short argument of the
Short
petitioner.
note also I have provided, my lord, and with the judgment.
This is
Upload this.
respondent number 4.
I am for respondent number 4.
You are 4.
Yes.
And
That is.
who's respondent number?
1 and 2.
You are 1 and 2.
1 and 2.
You have also given.
Written argument of my lord.
You have also given.
Fine.
Too many written arguments.
Yes, my lord. Everybody has submitted, my lord. Respondent
From
number
my
5
side,
also
my lord, only
submitted.
short notes, my lord, no.
Only short
Only short notes. And the
Respondent
judgment.
number 5 also submitted.
Suppose, my lord, if the institute is, my lord, recognized, even then, my lord, the respondent number 4 is not eligible, my lord. Because there is no specifically, my lord, they have mentioned that equivalent, my lord, there is no word of equivalent because he is not BE. Associate membership AB, my lord.
It is Thursday, बहुत matters है ना next Thursday. Next Thursday बहुत matters है. A coming Thursday.
No.
Thursday. I'll turn next Thursday. Huh? Na कौन लेना लियो पर तो. Friday. Friday do. Right, I'm having this matter for Friday. Let me just have a look into all the case laws. And if needed, you may have to give a little bit of clarification on Friday. Huh? If needed. So just have a look.
Our point is, my lord, this point has been already settled by this.
All right, let me just have a look
Yes.
at it. Friday for the hearing. It will be slip করে দিব এটা.
Hello. Lord, I prayed for time in the morning.
All right, how much time?
After vacation, man.
The other side is been informed.
I have informed.
Mr.
SK Chakravarti. ma'am.
Mr. SK Chakraborty, learned counsel appearing for the
Appellants, ma'am.
appellant, seeks accommodation for
Hello?
6 accommodation for how much? How many times?
After vacation, man.
6 posting of this matter after 2 weeks on the ground that
Well, actually, original records were handed over to the appellants. Actually, initially in this case, Mr. J.K. Paradoli was handling the
That
matter.
is on the ground that due to on the ground for reconstituting the brief, prayer is allowed. Prayer is not opposed. Relist after 2 weeks on a date to be fixed by the registry.
Deeply.
And the date did you again after vacation? And the date did just take the date. Relist on such and such date. Yes. What is the second appeal?
Mine.
Substantial questions where?
Lordship. Two substantial question of law formulated.
Where?
My lord, the first order, my lord, when the appeal was admitted, my lord.
It's not there in the body of the appeal.
The body of the appeal, there are substantial, page 3, my lord.
And order dated?
Order dated, my lord. 13/5/2016.
Yeah.
My lord.
Read.
My lord, whether the suit of the plaintiff is maintainable in view of the bar under section 154 of the Assam Land and Revenue Regulation Act 1886 in view of absence of prayer of declaration of title. And then 2, my lord, whether the impugned judgment and decrees are vitiated for non-compliance of provision of Order 20, Rule 18 of the CPC.
There was no declaration of title.
Mal.
What was the suit for?
Suit for partition, mal.
Partition.
Mal. My lord, plaint, lordship, page 6 onwards.
Where is it?
Page 6, my lordship. The plaintiff has filed the suit for a preliminary decree of partition of land measuring 2 biga 18 kata.
1 second.
Lordship.
Now, the trial court has decreed the suit.
Decreed the suit, my lord.
You are the defendant.
I am the defendant, my lord.
And the appellate court has also
affirmed.
So, concurrent findings.
My lord.
Yes. What is your main ground?
My lord, this lordship subject to my lord. Whether the impugned judgment and decrees are vitiated for
In partition suit, declaration of title is required.
Now, my lord, this Order 20, Rule 18, my lord.
Order?
20, Rule 18 of the CPC, my lord. And as far as my lord partition is concerned, my lord, in section 154, there is a bar of civil court, my lord.
There is a
bar of civil court, my lord.
154,
my lord.
Which section?
154 of the Land and Revenue Regulation.
Land Revenue Depot, CPCU Depot. Hundred
54, man. May I read?
Section 54. What do you look? 154. এখনো easy হবে না? 154
of Assam Land and Revenue Regulation. This will come after chapter 9.
Huh?
Chapter 9.
Chapter 9.
8 and 9.
Are you holding the same book? No.
No.
Just take it out.
Look.
Deduction. Okay. Beautiful. Thank you. Yes, read.
Except when otherwise expressly provided in this regulation or in rules issued under the regulation, no civil court shall exercise jurisdiction in any of the following. Question as to the validity or effect of any settlements. Question as amount of revenue tax. The formation of records and right. Then D, my lord, claims of person to perfect partition. E, claims of person to imperfect partition
Except when otherwise expressly provided in this regulation
my lord.
or in rules issued under this regulation, no civil court shall exercise jurisdiction in any of the following. Claims of persons to perfect partitions. So you are saying there is a bar
My lord.
for civil court?
My lord.
Yes. Yes.
Then, my lord, this second substitution of law, my lord.
But this is in view of absence of prayer of declaration of title.
My lord.
So a simple partition claim is not maintainable, you want to say?
My lord.
Yes. And second, yes, CPC?
Second, my lord, CPC order 20 and rule 18, my lord.
It is 20, rule 18.
One 18.
Yes.
Decree in a suit for partition of property or separate possession of a share therein. When the court passes a decree for the partition of property or for separate possession of a share therein, then if and in so far as the decree relates to an estate assessed to the payment of revenue to the government, the decree shall declare the rights of several parties interested in the property, but shall direct such partition or separation to be made by the collector or any other gazetted subordinate of the collector deputed by him in that behalf in accordance with the declaration and with the provisions of section 54. Now, my lord.
Yes, what do you want to show from here?
Now, my lord, in this case, my lord, the decree was passed, my lord, but the rights of several interested parties have not been rights of the parties.
Can you speak a little loud?
My lord, the rights of the several parties were not declared. Simply decree was passed holding that the
plaintiff has right title, he has the right over the suit land, my lord. But the suit is between the, my lord, stepbrothers and his brother sisters, my mother. The quantum of the land, my lord, who will get, how much land will get, my lord, that has not been described. And by this particular provision, my lord, it has been, lord, specifically provided, my lord, the decree shall be declared the rights of several parties interested in the property, my lord. And that to be done by the collector, my lord. Thereafter, partition should be affected by the collector, my lord. Here it is by decree, my lord, it was passed that partition by an Amin commissioner, my lord.
Yes. But whether that would be fatal,
My lord, until and unless, my lord, share is, my lord,
determined.
determined, my lord. First of all, that should be determined.
Right, let us see the appellate court's
Mal.
judgment.
Lordship starts from page 32, Lordship. Or 33, yo.
Page 52.
33, ma.
Yes, read.
This is an appeal under order 41 of CPC read with section 96 of CPC directed against the judgment dated 17/7/15 and decree dated 21/7/15 passed by the learned Munsif number 2 Ilakandi entitled case title suit case number 87 of 2010. The appellant plaintiff case is that Taibali during his lifetime married thrice. The first wife died leaving the principal defendant 1 to 4. The second wife died leaving behind the principal defendant number 5. Thereafter, Taibali died leaving behind the plaintiff, the principal defendants, pro forma defendant number 6, who are sons and daughters of pro forma defendant number 7 to 9. The disputed land measuring 2 biga 18 kata 5 chotaks are originally belonged to Taibali, falls under DAG number 78/490 under second RS Patta number 114. Taibali died before 10 to 12 years, and after his death, all heirs entitled to inherit the landed property in the following shares. Each 8 sons are entitled to get land measuring 8 kata 8 chotaks. Each daughter entitled to get shares 4 kata 4 chotaks, and wife 7 kata 7 chotaks 12 kata. Hence, the plaintiff's prayer for awarding preliminary partition, decreeing of the land mentioned in the schedule of the plaint, and further for a direction to the district collector Hailakandi for preparation of Shaham. Being aggrieved and dissatisfied with the aforesaid imputed judgment and decree passed by the learned court below, the defendant appellant preferred this appeal preliminary on the ground suit is the suit in question was a suit for partition where title of the plaintiff, title of the principal defendants and pro forma defendants have not been shown specifically, and imputed judgment does not speak so. Therefore, the judgment and decree are valid in law. The learned Munsif number 2 did not notice the amended plaint wherein the title of Taibali was shown in the shown to be 2 kata 18 2 biga 18 kata 5 chotaks, and same was to be distributed among the plaintiff and defendants and pro forma defendants. As per provisions of Mohammedan law and ignoring this aspect, the learned Munsif number 2 decided the title of the plaintiff respondent to be 2 biga 18 kata 5 chotaks for him alone. The decision of issue number 2 is completely wrong, illegal and untenable. The learned Munsif number 2 ignored the admission of plaintiff that his father sold 1 biga 1 kata 11 chotaks to Ismail Ali, and thereafter his father Tayyib Ali sold 3 biga 12 kata and 12 chotaks to defendant number 1 by deed number 1356 dated 31/12/1997. Thereafter, Tayyib Ali did not retain an inch of land to be inherited by his successor. Learned Munsif number 2 discussed above these two deeds, but he did not notice that Tayyib Ali left no land and therefore the decree is wrong and illegal. The learned Munsif number 2
did not take into consideration the result of cross-examination of plaintiff PW1 and passed the wrong degree.
1 second.
Lordship.
Mr. Dekka, for which matter are you waiting?
14 Milord. And by making early hearing application that fixed, so can it be on Milord LS 17 or 19?
All
Milord?
right, all right.
19 Milord?
19?
19.
I'll
Okay.
give your item number.
Yes, Milord. Thank you.
Give it there. Yes.
The judgment and decree are wrong in law and fact and liable to be set aside. After institution of the suit, summons were issued to the defendants. The defendants have contested the suit by filing written statement jointly wherein they have stated that the averments of plaintiff are false and baseless. According to principal defendants, while Tewali was the sole owner of the land consisted in Patta number 114 on 4/7/2014.
You are the sole respondent.
My
You are the
land-
sole respondent.
No, they are,
So, yes.
no, other respondents are there, my lord. There are 5 respondents.
They are here or not?
I am only for one.
Huh?
But this one.
Rest are there.
This is item number
8.
Item number 8, my.
8. You are for R?
I am for 1, 2,
R1.
1, 1, 2, 3, 4. 1, 2, 3, 4, 5, my.
The
One.
4 and
6.
2,
4,
3,
One.
4, 5.
3, 4, 5.
So all.
And 6. All, my.
Huh?
all,
All.
all.
Yeah, for the all
Yes,
the
all.
respondents. Yes.
My lord, after institution of the suit, summons were issued to the defendants. Defendants have contested suit by filing written statement jointly wherein they have stated that averments of the plaintiff are false and baseless. According to the principal defendants, while Beverly was the sole owner of the land consisting in Patta number 775, by deed number 401 sold to Ismail Ali and measuring 1 biga 1 kata 11 chataks under tag number 78/490. Thereafter, Toyvali on 31/12/97 white registered deed number 1356 sold land to defendant number 1 Rajamuddin measuring 2 biga under tag number 78/490 and another plot of land measuring 1 biga 12 kata and 12 chotaks under tag number 490/555. After the sale land measuring 1 biga 9 chotak remaining in the name of Toyvali again on 13/33/1998, Toyvali sold the land measuring 1 biga 4 kata 4 chotaks to Kadarjan and no lands remain in the name of Toyvali in the said patta after that sale. On 12/7/2007, Kadarjan again transfers his right title interest to Husna Begum, wife of Rajamuddin. Defendant number 1 and they are in possession. Thus, Toyvali during his lifetime exhausted his all lands by way of sale and he owns no land for partition and hence the suit is liable to be dismissed. The moot points came for considerations in the appeal are whether the court below has rightly appreciated the evidence of record on record in all issues in right perspectives to arrive at just decision of the suit, whether the judgment dated 17/7/15, decree dated 21/7/2015 passed by the learned Munsif number 2 highlighted entitled suit number 57 of 2010 is required to be interfered and liable to be reversed and set aside. After perusal of the judgment dated 17/7/2015 and decree dated 21/7/2015 passed by the learned Munsif number 2, Hailakandi entitled suit number 87 of 2010, copied in evidence on record, reveals that learned court below decided as many as 5 issues to arrive at the just decision of the case. In respect of cause of action for the plaintiff's suit, the learned court below rightly decided in affirmative as pleading of the plaintiff who is son of late Toyvali, who is also entitled to for the shares which was left by his father. The fact has been denied by the defendant appellant as thus the matter is dispute is required to be adjudicated in the court of law. In respect of vital issue number 2, whether late Toyvali died about 10-12 years ago, leaving behind suit land as joint property of the plaintiff and defendants. From the evidence on record, it is evident that plaintiff and defendants are the legal heirs who had 8 bighas of land under patta number 114 bearing tag number so and so, that is exhibit 1. To this extent, there is no pale of controversy between the parties. In the ground of appeal, that there is an admission of plaintiff that his father sold 1 bigha work katha 11 chotaks to Ismail Ali, and thereafter his father Tayyib Ali sold 3 bigha 12 katha and 12 chotaks to defendant number 1 by deed number 1356 dated 31/12/97, and therefore Tayyib Ali did not retain an inch to be inherited by his successor. In the amended plaint, there where the title of late Tayyib Ali was shown to be 2 bigha 18 kata 5 chotaks, and the same was to be distributed among the plaintiff and defendants as per provisions of Mohammedan law. Correct, it is that the land measuring 3 bigha 12 kata 12 chotaks to one Rezamuddin by executing a registered deed 1356 dated 31/12/1997. The remaining portion of land 2 bigha 18 kata and 5 chotaks is the subject matter of dispute. According to defendant number 1, the said portion of land sold to Kadarjan Kadarjan Bibi by executing Swarnolipi exhibit T by late Tayyib Ali. Then subsequently Kadarjan sold said plot of land to defendant number 1, that is so and so. Now question probed whether Swarnolipi confers right and by virtue of which an immovable property can be transferred by way of sale. On this aspect, learned court below discussed the provisions of 54 of Transfer of Property Act. The said provision has made amply clear that any immobile property.
I can't hear you.
My lord. The said provisions has been made amply clear that any immovable property valued more than 100 must be transferred by registered instrument. Even if we consider the title of late Tayyib Ali was shown to be 2 bigha 18 kata 5 chotaks, and the same was to be distributed among the plaintiff and defendants and pro forma defendants as per Mohammedan law, but in what manner it was transferred and what quantum of land to the respective legal heirs of late Tayyib Ali has not been specified in the evidence of defendant. Having considered of the fact stated above, in my opinion, the learned court below rightly decided in affirmative that late Tayyib Ali left the joint property to the extent of 2 bigha 18 kata 5 chotaks land as Swarnolipi, and exhibit D Kacha document are found to be invalid in the eye of law. So far as transfer of immobile property is concerned, as the plaintiff is one of the legal heir of late Tayyib Ali, his joint right title interest over the suit land cannot be ignored. After scanning the entire judgment passed by the learned court below, entitled suit 87 of 2010, coupled with evidence record, I do not find any merit in issue or to interfere as such. In my opinion, learned court rightly decided the case in proper perspective, and thus interference unwarranted in absence of merit. Now, my lord, in the evidence of PW1, my lord, he himself admitted, my lord, and that has been reflected in the order itself of the trial court, my lord. Plaintiff himself admitted about the transfer of the land, my lord, to the defendant, principal defendant, my lord. He has stated in, my lord, in page 19 of the trial court judgment, my lord.
All right, another date.
Lord.
It's already time. Kita di bapa. Kita di bapa itu. That is next. কি হয়? Thursday না Friday? 10th koisa. 10th.
But some other matters on that day fixed.
Acha,
Can it be on 19, man?
19th.
One.
19th would be difficult. Then 24th.
Obliged.
List on 24th. Due to positive time, hearing could not be covered.
Obliged.
24th.
Post list now, I say.
Apply.